nature of the charges, his possible penalties, and his constitutional rights?
Yes, Your Honor.
Okay, so defendant stands mute. A not guilty plea shall enter. We have an address on Coolidge Highway for this gentleman. Mr. Stack, is that your current address?
Yes, Your Honor.
Okay, and do we have a phone number that can be chatted or stated to the court?
I'll chat it, Your Honor.
Okay. Are you chatting it to me or to the clerk?
Let me see here. It says I could do it to the magistrate. Yeah, to you.
Okay, go ahead, sir. Thank you. The court has received a phone number ending in 0603. I'll put that into the ROA. Give me 1 second, please. Okay, and what do you have to say about bond and bond conditions, counsel?
Your Honor, I'm asking for a personal bond. My client is 38 years old. Other than a misdemeanor when he was
report of a violation of your community control. The allegations are on February 11, 2026, you failed to provide documentation verifying completion of the corrective thinking program as ordered by the probation department. And as of February 11, 2026, you're refusing treatment or the treatment recommendations. You were ordered to do this. This could result in revocation of your community control. And we would then look at your sentence again. You have a right to be represented by an attorney. If you can't afford an attorney will be appointed to represent you. You're facing 36 months. And how much credit does he have?
Your Honor, has 346 days credit.
I'm sorry. He has
346 days.
Okay. All right. Would you like to have an attorney to represent you?
Yes.
Okay.
All right, here's pen. Go ahead and read the affidavit and then sign right there. There's this card.
You find probable cause, Judge?
I'm sorry.
You find probable cause?
Yes. That's a lot of time for somebody who got community control. I'm just thinking he didn't go to prison, but he managed to spend almost a year incarcerated. Do you know what happened here? Was he?
According to the PSI, Your Honor, he already had 331 days at the time of the sentencing.
Okay. All right. Do you have any questions, sir?
Your Honor, I did get pretty much the violation. I got it from pretty much a knife. I got that from December for a Christmas present, but I was just going to give it away. But that's mostly what the violation was for. I just couldn't make it up here in time.
I'm sorry.
For the violation, pretty much I couldn't make it up here because it was for a knife, but I couldn't make it back and forth since I didn't have a ride back, change out insurances and all that good stuff.
Okay. Well, Mr. Newberger, I think he's here. Is he may be on one of Judge Oda's cases. So, that's in the afternoon. Call Mr. Newberger, talk to him about your situation, and then we'll get you back in here as soon as we can to address it.
Okay.
All right, thank you.
Ms. Hinkle, does your client wish to have a contested hearing in this matter?
No, Your Honor.
Mr. Foster, do you understand the rights you're giving up by admitting to this violation?
Yes, Your Honor.
Do you admit or do you deny that you violated the terms of your probation?
Admit.
Based upon your admission, I find you have violated the terms of your community control. Ms. Kennard, anything on behalf of Ms. Stewart?
Your Honor, she doesn't necessarily want to make a statement. She just is asking that the defendant be sent to prison.
Mr. View?
Your Honor, given Mr. Foster's repeated violations of community control, he absconded for nearly 4 months, his continued drug use, I think that he is no longer a candidate for continued community control. I think there's been a lot of efforts made to direct services towards him, mostly because of the extent of the restitution owed, but he hasn't been doing that either. State's recommendation is that his probation be revoked and that he be sentenced to the reserved sentence. There's 21 days of jail time credit.
Mr. Schmidt, anything for probation?
No, Your Honor.
Ms. Hinkle?
Thank you, Your Honor. After talking with my client, my understanding is that he did miss a couple of the scheduled office visits, but he was still making his status conferences, all except for, I believe, one of them. With the report for failure to report and the change of address, my understanding is he just didn't have a permanent address at the time, and so he was working on trying to figure out what his permanent address was going to be, which he now has. As far as missing the restitution payments, my understanding is that he got out of prison in October of 2024, and so he did miss the November 24 and December 2024 payments, but he did make a payment about $3,200 in January. The months that he has missed, he has tried to, make extra payments the following months, and then just starting September of last year, he was just going through a rough period of time in the toxic relationship. He's now left that. He is now working for doing subcontracting, construction, remodeling, and he would really just like a chance to get out so that he can get back on track with making the restitution payments.
Mr. Foster, anything you want to tell me?
No, Your Honor.
We did everything we could, Mr. Foster, because I always thought that it would be better for the victim to be made whole in this case. It seems apparent that's never going to happen. So I am going to sentence you to 18 months in prison. I'm going to give you credit for the 21 days you have already done. You do have the optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after your release. And if they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time that you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. Ms. Stewart, I am sorry, this probably means that you're never going to get your money, but I feel like we did everything that we could. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the costs, they'll all be provided to you without charge. Good luck to you, Mr. Foster.
Thank you, Your Honor.
I had the address when she put the warrant out on me. She just didn't know. I got the apartment, 4917 Shirley, 45238. My landlord phone number is 827-2334. You can call him. His name is George. and talked to him. I got an apartment, and I was put out the shelter for not being a Christian, not because I was being bad. Everybody heard it. A guy, the day that I got put out the shelter, the pastor was in a bad mood because a guy had overdosed in there. He died. We was in church. He went back to the dormitory and got high and overdosed while we was in church. So they came, the police and the ambulance came in there and told us we wasn't allowed to leave the church. And so the pastor was in a real bad mood. He said, you guys got to stay in the church. Y'all can't take no naps. Y'all can't sleep in here. I said, this ain't jail. We can't take a nap. Service is over. He said, no. I said, I appreciate the church service, but I'm not a Christian. Do I have to go to church? He said, well, since you're not a Christian, you can pack up your stuff and leave right now. He was mad because the guy just committed overdose. It took it out on me. That's why I'm here. And then I was attacked on Liberty Street. On December 22nd by a drunk guy. And this truck had pulled up, this big RV had pulled up and passed out a hygiene pack for us and gave us a backpack and a blanket with stuff I needed because I'm living in the streets at this point. So she, well, technically I'm not living in the street, but I still needed this stuff. But a guy walked up to me, attacked me. Well, I was sitting down in the chair. He attacked me. The police was like a block down the street and they saw him attack me, okay? They charged me with disorderly conduct and obstruction of official business. And I was in Justice Center for 50 some days for this case. And my lawyer that they gave me violated the rules of the court, and they fired her and gave me a guy named, they gave me the director of the public defenders in Hamilton County to represent me because my lawyer misrepresented me, and he fired her for waiving my speedy rights trial and causing me to do all that time in the county jail for disorderly conduct. So I went to court for that. The judge dismissed them charges because I was attacked and I didn't do nothing wrong. And plus, I was forced to sit in the county jail longer than what I was supposed to because the lawyer never showed up for court for all her clients, and she got fired as a result of that. So I got a lawsuit pending in Hamilton County for that. Erica Underwood has said she's gonna represent me for that lawsuit.
So you're giving me way too many details here.
Okay. I've been through a lot of stuff because of this warrant that she put on me for not having an address. And I got the address shortly after she put the warrant on.
Well, the allegations here that you have to deal with are on December 7, you were found to be non-compliant with regulations for Hope House, and that resulted in a discharge.
That was a voluntary homeless shelter. I wasn't forced to go there. She gave me a ride there.
Okay, I've already heard all that from you. On December 10, you were ordered to contact probation department no later than 4 p.m. and you failed to follow orders resulting in a warrant. So you need to tell your attorney this story, and then he can sort out what he thinks is relevant to these charges and address it at that time. I will tell you this. I've been here, my next anniversary here will be 17 years here. It'll be September. So let's say 16 and a half years. I have never heard anyone say they were kicked out of the Hope House because they were not a Christian.
I got witnesses.
Well, then I'm just saying you're the first I've heard.
I got witnesses though, and my lawyer can call them.
Okay, well, talk to your lawyer.
But the Hope House, I wasn't sentenced to the Hope House. That's a homeless shelter.
I know what the Hope House is.
I voluntarily went there. I didn't have to be there. She got upset because I left the Hope House and violated me for not having an address because she got upset because she asked them to let me stay there. I didn't do nothing wrong.
Okay, you're gonna have to have a hearing on this. Talk to your lawyer. Find probable cause though.
Yes, sir.
I didn't even do nothing, man. I don't have to stay at the homeless shelter.
Nick.
Morning, room.
Nick Berninger. Okay, we're here for preliminary probation violation hearing for Mr. Berninger. Are you aware of the charges?
Yes, Your Honor.
How does he wish to proceed?
We would like to admit the violation and waive the formal hearing.
Okay. Anything from the state?
Judge, first, I'm having trouble hearing because Mr. Powell is still not wanting to stop talking.
Okay.
So if he could be quiet, that'd be great.
Yeah, sir, you need to stop talking.
Judge, I'm
Wait
regarding
one
this
minute.
gentleman.
One moment.
Yes, sir.
Mr. Powell, please stop talking. We've got other things going on here. Okay,
So Judge, from the state's perspective, I'm aware of the recommendation of probation. We would defer to that.
okay, thank you. Mr. Gibbs, anything on behalf of Mr. Berninger?
Yes, Your Honor. I would just say we also would be in agreement with the recommendation of probation. In discussion with Mr. Berninger, it was an unfortunate situation. I believe just personality clash that led to this. A lot of misunderstanding on both sides, I believe. But we admit the violation and would like to move forward. And again, are certainly in agreement with probation's recommendations.
Okay, thank you. Mr. Berninger, is there anything you'd like to say, sir?
It's just miscommunication between the River Rocks recovery and myself as far as the updated statement that got sent over to community corrections from them on my behalf. And it was, I thought I was doing everything I was supposed to do when they said differently. And I had negative drug screens for over 2 months there and was showing up the 3 days a week I was supposed to for IOP, and I was being told I was doing good, and when they sent over something totally different. So I was being compliant and doing what I was required to do from probation and treatment, and I hope that I can get another chance and continue to do it over again to get back there because of my 2 jobs and the family and everything.
Okay. Just so you'll know what we're dealing with here. That's your side. Here's what the report says. Their input was you were becoming increasingly defensive and at times disrespectful toward the staff. You continue to openly express disrespect toward the program during group sessions, which is disruptive and non-conducive to your peers. Treatment experience, you reported that you did not feel you needed to comply with the policy and believed it could you could provide a screen the next day when he felt you were ready. You did not submit to a drug test on the 9th when treatment when ordered. So it's a very different story than what you're stating here.
And that's why I was in such disbelief when Officer Torek had read that to me on this past Thursday when I got arrested, because that's not what they were telling me. They were telling me that they see the progress in me, that the effort that I'm putting into it to make the better of the change and everything. And then that's what they write about it at the end of the day. And I was shocked.
Okay, well, here's the situation. I'm going to order that you're released on GPS monitoring for 60 days with a curfew, that you submit to random drug testing with the call-in line with probation. What that means is you call in, they tell you whether or not you need to come in that day. And if you do, you have to get here.
Yes, sir.
And you enter and successfully complete it. Well, first of all, you complete an updated assessment and follow the recommendations and aftercare related to it. So we're going to give another assessment, and you're going to follow the recommendations of that assessment. If you come back and I'm getting a different report that's very similar to this, then I don't think you're conducive for treatment and you'll have to spend time.
Right.
Okay.
And I had an assessment scheduled already for Friday. I'll just call them back and get it scheduled again.
You mean last Friday?
Yeah, for at Woodhaven.
Okay, well, I don't know if they've got one that they're going to get for you or not.
Well,
but-
no, I was just saying I can call them if I, as a option for a treatment center to get the assessment through from.
Talk to your officer.
Yes, sir.
Okay, that's all.
Thank you, Your Honor.
Thanks. Thank you.
Okay, just keep your voice up nice and loud for me.
Sorry.
That's all right. This ticket was issued January 6th of 26, it appears. Or actually, it was issued on the 15th, but on the 6th of January, they said you had a blight condition at your residence at 26771 Allen Road in Woodhaven. You have the right to an attorney. If you want one, I will provide you with one at public expense. Would you like a lawyer?
Is it just blight ticket?
That's all I have in front of me.
I just pay that thing?
It's a misdemeanor, and you're going to have to remove the blight condition.
Yeah, so I've got all that. I have another case that I had the blight ticket. I thought all this was like together with that.
Well, let's not get ahead of ourselves. You haven't been convicted of this. Do you want a lawyer, or do you want me to arraign you and send you to the prosecutor to discuss it?
Yeah, for the prosecutor to discuss.
So you're going to waive your right to a lawyer right now?
Yeah.
On January 6th of 26, they think at 26771 Allen Road in Woodhaven that you had a blight condition. The citation's not very specific other than saying that. So that's all I can tell you. It's a misdemeanor punishable by up to 500 fines, 90 days jail, costs of all those. You understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes.
All right. So you waive your right to a lawyer still?
Yeah.
I'll enter a not guilty plea. Personal bond. You don't have to post any money. I'll give you a $500 personal bond. You can not leave the state without the consent of the court or violate a law. You must appear in court as directed. You go out there, John, take that to Woodhaven when you get a minute, and they'll call you. You're going to go right outside the prosecutor's door there, okay? Do they have to sign in, John?
Yes.
You have to sign in out there then, okay? Thank you. Just the one with. Which one do you have, Mr. McCandless?
I have Mr. Hagar, Your Honor. Magar, M-A-G-A-R. I'm sorry, Magar.
Byru Magar, 26W841213. All right. Good morning again. Your name?
Morning, Your Honor. Glenn McCandless, if you have Mr. Magar.
All right. So you're going to plead to impeding on his behalf.
Yes, Your Honor.
Improper lane use will be dismissed. True?
True, Your Honor. Yes, Your
And
Honor.
you're authorized to enter this plea on his behalf
I am, Your Honor.
to the charge impeding traffic, responsible or not responsible.
Responsible, Your Honor.
All right. Please accept it. Improper lane use is dismissed. This is a commercial vehicle, $220, and I'll give them until the 25th to pay, okay?
Thank you, Your Honor. Have a good day.
You too. Thanks a lot. Take care. Raymond Hamill, 26W840317. Sadie,
They're coming in on Zoom, Judge.
what date is that? Heather, I got a court to school program, and I want to make sure that I get some people for that. It's in March, but can never start too early. Do you know what day that is, Heather?
I do not, Judge. I need to look at that.
Okay, no problem. Mr. Gilbert, good morning. This is 26W840317. Your appearance?
Good morning, Honor. Mark Gilbert, P71034 for defendant, who's obviously present with me via Zoom.
All right, sir, your name?
Raymond Hamill.
Okay, good morning to you both. Counsel, your client pled guilty to operating while impaired On February 4th, he was referred for a screening and assessment. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
The report is in his hands or on the desk in front of him as we speak. We reviewed it this morning. It is factually accurate.
Okay. Anything that you would like to say on his behalf?
Sure. I can actually quote my client. He came in this morning and obviously noting he's been cooperative with all this and very forthcoming, but I've never had a client put it this way. He said, this is completely self-inflicted. And I mean, when he was in probation, he obviously took responsibility, but he continues to do so while he was with me this morning. This is a singular event. This is not a, obviously the probation accurately assessed his alcohol issues. This is not somebody who's a constant problem drinker. He's a 5-6 times a year drinker, but he absolutely owned up to the situation as it was. So I think we've got a good candidate going forward. I would ask the court to adopt the recommendation as it is. Both my client and I think it's reasonable and warranted.
Okay. Is there anything else?
I don't think anything further, Your Honor.
Mr. Hamill, would you like to say anything, sir?
No, sir.
8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. So I'm going to go along with this recommendation, but you're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you attend a level 1 alcohol education program with the Victims Impact Panel, okay? I'm going to order 3 days jail, credit 1, serve 2, and I'll let you serve those by way of community service. So I'll give you 16 hours community service. And that is due by May the, let's see. Yeah, April the 7th, okay? You have to have 16 hours done. Fines are $300, costs $375, $75 victims' rights fee, $50 justice assessment fee. Your total fines and costs amount to $800. Probation fees are $160 for $960. And then you have a screening fee of $60. I don't think there's cost of recovery in Woodhaven. You guys didn't talk about that at all, did you?
We did not, Your Honor.
1,020 is your total. You're getting away pretty light here, but you know what? You scored in category 1 on both the alcohol and drug use portion. That tells me you don't have a problem. So you may be eligible for early discharge. You get everything done in 4 months, you can apply for early discharge. Okay, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
Okay, can he pay all this today?
I believe he will. Yeah. I believe he will be at the court forthwith as soon as we're done.
Okay, so you can pay it, then go over to probation. They should be able to meet with you today. They are a little short-handed right now, but if not, they'll schedule your appointment for you to come back in and explain the order, all right?
Your Honor, you will have whiplash. He'll be there so fast.
Nice to see you, Mr. Gilbert. Take care.
Have a
Good
good
luck,
day.
Mr. Hamill. Thank you.
Thank you, sir.
Antanasia Brianna Dozier, 26W841212A and B. And could I have Mr. Davis, Ralph Davis, is he here? Have a seat at the table. Ma'am, come on up to the podium and tell me your name, please.
Antanasia Dozier.
You're charged with driving on a suspended. You have the right to an attorney. You also have a second charge of speeding. Would you like an attorney to represent you? Okay, I'll go ahead and arraign you, and then I'll send you to the prosecutor. On January the 8th of 26, it is alleged that you did operate a motor vehicle in the city of Woodhaven, County of Wayne, on I-75 near West Road at 11:57 in the morning. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs, or all those. 2 points would be added to your traffic record. You also have a speeding charge that would be a 1 point violation. You're charged with 80 and a 70, even though he has you clocked as going is driving 90 and a 70. Do you understand that?
Yes.
Okay. Did you sign the advice of rights and read and understand these rights?
Yeah.
Plead guilty. You'll be giving up all the rights. There will be no hearing or trial. Do you understand that? If you plead guilty at any time, we're not going to have a trial. Do you understand that?
Okay.
Do you?
Yeah. But what do that mean? Do you get like?
I'm just telling you, if you plead guilty today, tomorrow, in a week, a month, you're giving up your right to a trial if you do that. Do you understand that?
Yes.
If you plead guilty, we're not going to have a trial because the conviction would enter then when you plead guilty. And you'd be waiving the rights, the presumption of innocence, the requirement that they prove you guilty beyond a reasonable doubt, your right to remain silent, your right to cross-examine their witnesses, your right to bring in your own witnesses, your right to use the subpoena powers of the court to bring in those witnesses, and to testify or remain silent. Do you understand all that?
Yes. But I'm still kind of confused.
Okay, tell me why you're confused.
Okay, so if I plead guilty, does that mean I'm making it worse on myself?
No.
Because
Oh, wait, just slow down. Let's slow down.
okay. If I don't.
You're gonna go, here's what I'll do. You said you waived your right to a lawyer. I'm gonna send you to the prosecutor.
Okay.
I'm gonna give you a personal bond.
Okay.
I'm entering a not guilty plea. You can go talk to the prosecutor, see what the prosecutor will offer you. If the prosecutor doesn't offer you something that you want, then you come back in here and tell me, Judge, I want to set it for another pretrial and I want a lawyer, in which case I'm going to have you fill out a petition for a court-appointed lawyer. And if you qualify because you're indigent, then I'm going to appoint you. Do you understand that?
Yes. Okay. All right.
If you have another question, go ahead and ask it.
Okay. But if I plead guilty, does that mean I just pay money or I gotta go to court again? Do you get what I'm saying?
If you plead guilty, I'm probably going to sentence you.
Oh, no. I'll just see a prosecutor. I'm sorry, I don't know, like, you making me confused by saying.
Why am I making you confused? I'm not going to.
I don't know what you're saying.
What part don't you know? Do you understand the possible penalties? I have to tell you what the maximum penalties are.
Okay, what's the maximum?
Up to 500 fines and 93 days jail and 2 points on your record. If you pled as charged to driving on a suspended.
Okay, yeah, no, I see a prosecutor because I didn't know my license was suspended. So I'm just gonna see what I can do.
Well, I wasn't encouraging you not to see the prosecutor.
No, but you making it more clear to me, so I would just see them and then come back.
Go out and talk to the prosecutor, see if you can work something out. If you can't, come back in here. Either way, you're coming back in front of me though, okay? Thank you. Ralph Davis. Ralph Otis Davis, 26W41234A, B, and C. Your name?
Otis Davis.
You have drive while suspended, drug paraphernalia, and improper plate. You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer? I'm going to go ahead and arraign you and send you to the prosecutor on January 7th of 26. The police think you were operating a motor vehicle in the city of Woodhaven on Allen near West at 11:55 p.m. They think you had a suspended license that is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, costs for all those. You also have a drug paraphernalia charge. That's punishable under local ordinance by up to 500 fines, 90 days jail, costs for all those. You understand that?
Yes, I do.
You also have a third charge of improper plate, which is punishable by up to $100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, I do.
And did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes, sorry.
Do you understand what I've said, though?
Yes, I do.
All right. You still wish to waive your right to a lawyer?
No, I think I'll take a lawyer.
Okay. I'm going to enter a not guilty plea for you.
Okay.
$500 personal bond. You cannot purchase, possess, or consume alcohol or illegal controlled substances. Do you understand?
Yes.
You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll set you up with a court-appointed lawyer. He just needs the pre-trial, John. So you go out in the hallway, we'll set you up with your lawyer. Any questions?
No, sir.
All right, good luck. Which case do you have, Mr.
Sir. Oh, good. Oh, I thought it was.
Mr. Holmberg, what case? With Jagus?
Yes.
Okay. Adriana Giselle Jagus, 2678-40321. All right, good morning.
Good morning.
Ma'am, your name?
Adriana Giselle Villegas.
So we're gonna set this pretrial for 2 weeks out.
Just so the court's aware, I went to Brownstown Friday and today, before I came to court this morning, Alona said she was still downloading the dash cam and the body cam video, so I checked just to clarify.
That's fine. We're gonna do the 4th, Heather?
Yes, Judge, we can do March 4th at 8:45.
Okay.
Thank you. And she's got proof of right to see it.
No, I trust you. She's been going once a week, right?
That's correct, John.
Yeah, so you just take her down the hall, get your new date. Ma'am, do you have any questions?
No.
All right, thanks so much. Have a good day. Thank you. Mosgrove, Sierra Lynn Mosgrove, 25F244834.
She's on Zoom, Judge.
Okay. Ma'am, your name?
Sierra Mosgrove.
All right, you got to take care of your tickets quicker. Can you pay this today?
I don't. I'm unemployed. Honestly, I'm currently pregnant with twins.
Congratulations.
Thank you.
Well, when can you pay this? It's up to $153 now, ma'am. You can't just ignore a court like this.
Yeah, I know. That's why I called to get the court's date in order to speak on why I even received the ticket. My car was parked at my son's bus stop.
I'm not going to go. Hang on. I'm not going to go back and revisit the ticket. You should have shown up back in October. Okay, I can't revisit the ticket. There's nothing to revisit. You didn't show up and you lost. I'll give you some time to pay. I can do that for you.
So I didn't know there was another court date. They told me this was the only one that was scheduled.
You didn't show up. You didn't call and schedule a court date, ma'am. We issued a show cause for failure to appear and pay.
I called to schedule the appointment, and that's when they told me this one was already in place.
This one of February 18th. We didn't schedule this until just a couple of weeks ago or so. January 15th, we scheduled this. You needed
Yeah,
to
I
call
never received anything about a prior court date.
because you didn't schedule one. They issued the ticket to you and you didn't do anything about it. The ticket was issued to you back on September the 30th.
Yeah, I called to get set up for a payment plan, and that's when they told me I had to come in to do the court date.
The court date's today. You didn't call for months. Okay, so I don't know what to tell you. I can't do anything about the ticket. If you want, there's nothing I can do.
Okay, so there's no like payment plan I could get put on for that?
No, I told you I'll do a payment plan for you, but I'm not going to set aside the judgment that was entered because you didn't show up for 5 minutes.
That's fine.
All right. Do you have anything at all today?
I have nothing. I'm unemployed currently. I'm high risk with twins, so I'm bed rest pretty much.
Okay. Are you married? Do you have
No.
Is the father in their lives? Is he going to help you pay this?
I'm single. So I'm gonna have to figure it out. But what is the minimum payment plan?
You just tell me how much you can afford to pay and starting when.
I mean, realistically, nothing. But I'm gonna have to figure it out.
whatever I could do. Is it like monthly? I'm not sure. I'm new to this. I've never done this before.
I'll set up a monthly payment plan. How much can you afford to pay per month?
Would I be able to do like 10 to 20 bucks or something like that monthly?
You pay $20 per month, and I'll start you beginning March the 15th and the 15th of every month thereafter. How's that?
Okay, that's fine. And you said the total is up to 153 now?
Yes.
Okay, thank you so much.
Balance I'll reduce, but this is contingent on you paying the ticket. Balance reduced to 125, okay? Next time, be more adult about this, will you please?
Yes, Your Honor.
All right, good luck. So I'll reduce it to 125. You pay 20 per month beginning March 15th. If you don't have the money, no problem. Call the court. We'll go on Zoom and give you another extension. Don't ignore us though, okay? Good
Okay,
luck.
and now this doesn't affect anything with my license or anything like being suspended, correct?
No,
Okay.
no. Okay,
Thank you so much.
good luck. Thank you.
You too. Bye-bye.
John, pull her file.
It should be up there.
Is it Lori Hinkle?
Yeah.
Come on up here. Lori Gay Hinkle, 26W841130A. And B, your name? You weren't drinking today or last night, were you?
No.
Are you sure? John, did you go near here?
I didn't smell
You have the right to an attorney. I'm going to give you an attorney. Okay? And then you can talk to your lawyer, and either way, when he's done talking to the prosecutor, you two are coming in front of me, okay? All right, good luck. Randall Patrick Watson, 26W841071A and B.
He is also on Zoom. He's out of state, Judge.
Yeah, Mr. Watson, start your video and state your name, sir. Your name?
Randall Watson.
All right, you're charged with disorderly person, public intoxication, and resisting obstructing an officer. You have the right to a lawyer. If you want one, I will provide you with one at public expense. Would you like a lawyer?
No, sir.
I'll go ahead and arraign you then, and I'll explain the charges and your rights, and we'll go from there. On January 22 of 26, it is alleged that you were at 20990 West Road at the Buffalo Wild Wings in the city of Woodhaven at 11:16 p.m. and they think you were disorderly, public intox, a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. They think you had a PBT result of 0.248. Do you understand that?
Yes, sir.
You're also charged with resist and obstruct an officer. That is a misdemeanor. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing of any kind. You understand that?
Yes, sir.
So I'll enter a not guilty plea for you. I'll send you to the prosecutor. Listen, I'll send you to the prosecutor. I'm going to give you a $500 personal bond. You don't have to post any money, but here are your bond conditions. You can leave the state. You live in Texas, right?
Yes, sir.
You can leave the state to go to Texas without consent. You're not to enter, not that you're going to be here. I don't know what you were doing here, but you're not to enter 20990 West Road in the city of Woodhaven or any other Buffalo Wild Wings. You're not to have any contact with prosecution witnesses. You're not to purchase, possess, or consume alcohol, illegal drugs, or marijuana. Do you understand that?
Yes, sir.
All right, so I'll send you to the prosecutor and you can work that out. And if you can't work it out, you want a lawyer, I'm entering a not guilty plea, as I said. If you want a lawyer, you tell me when you talk to the prosecutor if you don't think you can work it out, okay?
I mean, sir, if it's all the same, I'd just like to pay the fine to be done with it.
No, just go talk to the prosecutor. I'm trying to be fair with you here, okay? It can't hurt you.
All righty.
All right?
Thank you, sir.
What school's in Lubbock again?
Texas Tech.
I thought so. Okay. All right. Have a good luck to you. We'll see you back on here in a few minutes whenever you're done talking to him. Thank you.
I'm
Yes,
going to
sir.
put you
Thank
in
you.
breakout room 1, Mr. Watson, okay, with the prosecutor.
All righty. Thank you, ma'am.
Breakout room 1. Dustin Lee Haupt, 26W8411057.
Dustin, yeah.
Good morning. So we're going to adjourn this.
Yeah, I've spoke with the ordinance officer and that's what we're trying to get a hold of her already. So I try to get all this resolved with it.
Yeah, we're going to give you 4 weeks. What's 4 weeks from now? Is that going to be the 18th, Heather?
That's correct, Judge. We can do 8:45.
Okay, at 8:45. Down the hall, we'll give you your notice. Just make sure you got the blight condition taken care of, okay?
Yep.
All right, and go right down the hall and you'll be handed a notice. Thank you. Good luck. People against Dozier. Antonasia Brianna Dozier, 26W8412112A and B. Okay, so ma'am, your name?
Today, you know,
All right, you got to go clear all these warrants. You got a ton of warrants.
I just found that out.
You got 3 out of Detroit, 3 out of Livonia. Go take care of your tickets. I'm giving you 2 weeks.
2 weeks. Oh, what's that? What's the date?
We're going to give you the 4th of March. At what time, Heather?
We can do 9:15.
At 9:15. Okay, ma'am?
Okay.
Go down the hall, get your notice, go over to Detroit and take care of those. And I'm sure this will work out well for you. Okay, best of luck.
Okay, thank you.
You're welcome. Sir, what is your name? Yeah,
Now this.
Hudson,
Yes.
Hudson?
Yes.
What do you seen on the docket?
Yes. I don't have this file.
What's that?
I don't have this file.
Is he here for arraignment and pretrial?
Show cause.
Maybe you can grab it. Can you grab that over there and, I'll call him and get in with the lawyer if he wants. All right. Take your time. Is that a show cause for a failure to pay?
Yeah.
That's probably the stack then. He's saying yes. No?
You get kind of this.
You're on there, I just, oh, you signed a new place, right?
I just looked up. It should be in a plastic sleeve for Donald Hudson.
We don't
If it's
have.
just-
John, double check with Sadie. She didn't find Donald Hudson. HUD.
Or I'm sorry, it will be in a file folder. I'm sorry, not a plastic sleeve.
Donald Hudson.
This is a short cross?
Yes.
On the first page.
Right back out there, then to the right there.
Yeah.
Cool. Thank you. Have a great rest.
Crawford is. He's talking right now.
This is Mr. Hudson.
You talked to Mr. Crawford, right? Yeah.
Oh, you did? Okay. Well, as soon as he comes out, we'll be ready for you, okay?
Be here.
Ah, good.
It also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Matthew Nicola.
Morning, I'm reading Cook the People.
Brother Judge, Torshall Feaster, Assistant Defender on behalf of Mr. Nicola.
Sir, can you please state your name?
Matthew Nicolai, sir.
Thank you.
Thank you, Judge. I believe this is the file with the MOU, if I'm not mistaken.
Yes, there was a memorandum of understanding. I think everybody has signed off on it.
I believe so.
Here, and I'm prepared to sign.
Thank you, Judge. My understanding is that Mr. Brown has reviewed everything with Mr. Nicolai. We've asked that the court follow the recommendation and give an opportunity to show this court that he can be successful, Your Honor.
All right. Sir, is there anything you'd like to tell the court before I do impose sentence?
No, sir.
All right. On the count one attempted R&O, sentence of the court, 24 months probation term with the supervision through the First District Court Veterans Treatment Court, $555 fines and court costs, which you'll have on the other count too. When can you get that paid, sir?
I can get that paid today, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. I'll order 365 days in jail. Credit 2, the balance is suspended. On the count 2 attempted R&O, 24 months probationary term with supervision through the First District Court Veterans Treatment Court, $555 fines and court costs. When can you get that paid, sir?
I can pay that today as well, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. 365 days in jail. Credit 2, balance suspended. All right.
Thank you, Judge.
Thank you. Cole,
Thank you,
best
sir.
of luck to you, sir.
Appreciate it.
Let's call the case of the People versus Byron Blair.
Your Honor, Raymond Cook for the People.
And good morning, Mayor. Please court, Your Honor, Attorney Damian Cash, P number 85852 on behalf of Mr. Brian Blair. Mr. Blair, if you can hear me, state your name loudly for the record.
Byron James Blair.
Brother Judge, Torshall Feaster, Assistant Public Defender, also on behalf of Mr. Blair on file number 2310991, Your Honor.
All right, thank you. All right, and what are we doing on these files?
Your Honor, at this date and time.
Go ahead, Mr. Cash. Apologies.
No, my apologies as well. At this date and time, I received this appointment from a withdrawal asking for an adjourned pretrial, as this is our first contact due to situation that Mr. Blair appeared to be in. And so I need to get his contact information so that we can have further discussions, Your Honor.
So I believe
and also have all discovery.
I believe we're also requesting adjournment, Your Honor.
My next day. Adjourned to the matter of March 4th, 2026, 9 a.m. on both cases. As to the contact information and like, Mr. Feaster, you can supply that to Mr. Cash? Or I'll wait.
And Mr. Blair, if you can hear me, I emailed you. Please also respond to that email while we get this contact information.
You don't even know what I asked. Do you? No, that happens when I'm talking to bowling too. I don't listen to anything. You'll supply contact information too. Okay. That was real simple. Thanks. All right. Thank you.
Have a good day.
We'll continue. Bye. Court calls the case People versus Albert Wilson.
Your Honor, Raymond Cook with People.
Morning, Your Honor. The winner appearing on behalf of Wilson. I'm going to file, so I'm substituting for him this morning, Your Honor.
All righty. And Mr. Wilson, you don't have, can you state your name first of all, sir?
My name is Albert George Wilson.
All right, and you don't have any problem with Mr. Winter?
I'm sorry, I can't hear you.
You don't have a problem with Mr. Winter stepping into?
No, I don't. I don't have any.
All right, fantastic. Sir, how are you doing?
I'm old and fat and gray and ugly. I'm the same as when you last saw me.
Okay, you're right. All right, no, I'm kidding.
I knew I was going to. I told you I was going to get through.
Sorry, I didn't mean to say it that way.
How you doing, Judge?
I'm doing great.
Good.
All right, what are we doing?
We just get, if the court will allow us, we'd just like to kick this over so Mr. Amadeo can be here and work out an arrangement with the prosecutor. Please, sir.
Well, March 4th, what do you think work for him?
Can we push it a little bit further, please?
18. March 18th.
That'll work.
2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Good to see you.
Yes, sir. You too. Court does call the case of the People versus Ricky Burdett.
Morning, Your Honor, Raymond Cook with People.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Burdett, who appears in person in front of you, Your Honor.
Yes, he's on his way up.
Okay.
Good morning, sir. State your name.
Good morning.
Your name?
Yes, Ricky Burdett.
Thank you. All right, what are we doing today?
Your Honor, it is my understanding that as of last hearing, my client was tendered an offer, that offer being a 1-for-1. So in that scenario, I did get a chance to talk to my client. He would actually like to plead guilty to the trespass, and in return, I believe the disorderly conduct would be dismissed.
Do I have a plea form? No.
I did not prepare a plea form. I was unaware that he was going to be pleading today. I can write that up right now. If we can pass the matter, I can get that done in just a minute.
All right. Sir, I'm going to pass the matter so we can write up the paperwork and then I'll take your plea. Okay? So go ahead and have a seat and then we'll call it right back up. Yes, sir.
And Your Honor,
I call back.
Yes, I might have sent an email to the wrong APA, so that's not his fault. That'd be my fault. I apologize, Your Honor.
You mean in terms of between you and Mr. Cook? It might be your fault?
Just telling him we were accepting the plea. That's probably my bad.
Oh, I realized it was I realized it was your fault. You didn't have to say it out loud.
Okay. Well, I'd rather just admit it. I feel better now, so I appreciate it.
Okay. All right. I'll pass it. We'll call it back up shortly. Court calls the case People versus Megan Maxson.
Morning, Your Honor, Raymond Cook with People.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Maxson, who now stands to my right. Ms. Maxson, if you could state your name for the record, please.
Good morning, Megan Maxson.
All right. Good morning, Mr. Hall.
Good morning, Your Honor. Great to see you.
Good seeing you. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the third degree in a 93-day offense. Upon her successful plea to that charge, count one would be dismissed. And there is a sentence agreement of the prosecutor's deferred. There is also an indication of no restitution. That's the court's full understanding of the agreement.
That is accurate, Your Honor.
That's a correct statement, Your Honor.
All right, may I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name, please.
Megan Maxon.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
I am.
She is, Your Honor, but it postdates the date of offense. This should not be an issue for probation.
Has anybody promised you anything that makes you promised you anything other than what's been stated here today to get you to plead guilty?
No, they have not.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of June 4th, 2025, at the location of 7,000 East Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what do you do at Walmart that makes you think that you're guilty?
I attempted to leave the store without ringing up floats and a coffee maker that were at the bottom of my cart.
Okay, so you were just going to push Pat. You were getting other things and just didn't ring those up?
Correct.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you took out, these were items that Walmart had offered for sale?
Yes.
Ma'am, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
I'm satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence. Defendant's ordered to probation for a pre-sentence investigation and report. Sentencing in this matter will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. Bond with its conditions will continue.
Thank you so much, Your Honor. Great.
I'm on your way down. I mean, probation department is on the left-hand side. If you could stop in and just see them so we can start the sentencing process.
Okay.
I'll make sure she gets there, Judge. Take care.
I don't trust. I told her. All right. Court calls the cases of the people versus Ryan Brown.
Morning, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Brown, Your Honor. Mr. Brown, you present?
Not here, Judge.
Yeah, good way to start. All right.
Yeah. So, well, our first client was here on the Zoom, so I'll take that.
You're right.
Your Honor, it doesn't appear as we have valid contact information for Mr. Brown. So I'd ask the court to consider sending this matter for a show cause. So hopefully we can take him.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. So give a 10% privilege. That warrant will issue immediately. Both of those. Oh, the other one is already warned him. Okay. Court calls the case People versus Brandon Davis.
Morning, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Davis is approaching, Your Honor. You just state your name for the record, please, sir.
Brandon Hezekiah Davis.
Judge, I spoke to Mr. Davis this morning. He's still working to clear up his driver's license. If we could get an adjourned pretrial date, we can continue to work to hopefully come back with a valid driver's license. We'd appreciate it.
How much more does he have to do?
I'm in paying like monthly.
A month, if we came back in a month, you think you'd have some progress?
I have progress for sure.
Okay, can we come back in a month, approximately a month? On the 18th, if possible, Judge?
In the matter to March 18th, 2026. 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, sir.
You're all set. We'll be in touch, okay?
Court calls case People versus Comaria Davis.
Brian Bowling on behalf of Ms. Davis. Can you state your name for the record, please?
Comaria Davis.
Judge, we'd like to get an adjournment in this case, if possible, to allow us to review discovery with Ms. Davis and to have a little further discussion with her regarding resolving the case. We could do the March 4th date. I think that could be.
March 4th, 2026, 9 a.m. Bond continue. Thank you.
And I can stop dates if you want.
Yes, I know. That's okay. I was gonna let you slide for a little bit. Court calls the case of the People versus Grant Decia.
Ready-ish, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Decia. I do not see him on Zoom, Your Honor. I do not see him in the courtroom. My recollection is he was here a couple of weeks ago. We have a no contest plea worked out, is in the file. I'd be requesting a show cause, so we can get a plea.
Where is this show cause? Yeah.
Mike taught me that. Yeah.
I got, yeah.
Yes.
Well, unlearn that. Potential warrant will issue bond 5,000. I'll give 10% privilege. That warrant will issue immediately. Thank you.
Thank you, Judge.
No, I'm not surprised if you just do that one time. Court calls the case, People versus Michael Elkins.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Michael Elkins. Your Honor, we did reach out to Mr. Elkins by phone and text message. I do not see him in the courtroom. I do not see him on Zoom. I do not know why he is not present. For the record, I would request an adjournment.
Bench warrant, 5,000, 10%. Warrant will issue immediately.
I did not say show cause.
You did not. Court calls the case, People versus Sincere Godwin.
Morning, Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Godwin. Who is she on Zoom? Rather, I don't see her in the courtroom. It doesn't appear as if she's on Zoom. I'd ask the court to adjourn this matter so that we can get in touch with her. I don't think we have valid contact information for her.
Bench warrant will issue bond 5,000, 10%. Warrant will issue immediately.
Thank you, Your Honor.
They're on a roll. Court calls the case, People versus Wilmer Hudson.
Morning, Your Honor, Raymond Cook for the people.
Oh.
Brian Bowling on behalf of Mr. Hudson is coaching. State your name for the record, please, sir.
Wilmer Hudson.
Thank you, sir.
Judge, I'm asking for an adjournment in this case. We did have a meeting scheduled with Mr. Hudson to review some video footage, but unfortunately, there was a bit of a technical glitch with the person who was going to review it with him. We couldn't get that accomplished. So we'd like to come back and get that after getting that accomplished.
You'll be able to do that by the 4th?
I believe we should be able to, yeah.
March 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you. We'll be in touch. Thank you.
Court calls the case, People versus Paula Johnson.
Morning, Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Johnson, Your Honor. You state your name for the record, please.
Paula E. Johnson.
Your Honor,
where have you been?
What do you mean? Here we go. I know.
What do you mean? Here we go. Here we go.
Here we go.
You know,
or should I stand? Here we go. Yeah. So where have I been? I've been in school.
How you doing?
I'm wonderful.
Okay, great.
I got a year or two before I get my bachelor's, so working hard at it.
Okay.
Yeah. This was just a glitch along the way, so.
Okay, but you're doing well otherwise.
Yeah, I'm doing really
okay,
well.
that's what I meant to say.
Okay, I know what you meant to say, but okay. We'll let that pass.
Okay,
anyway.
all right.
All right, yeah.
All right, now that we've had our greetings, Mr. Bowling, what would you like to
I spoke to Ms. Johnson today, obtained a updated phone number for her, which we did not have a valid phone number until I saw her this morning. So I'd like to get an adjournment so that we can speak to Ms. Johnson and hopefully be able to come to a resolution of this matter.
Okay.
How long would you like?
How long would I like? It doesn't.
Now, I wasn't asking.
Okay, give me about a couple of weeks then, a month. I don't know. What works for you, Judge? I'm just saying. What? I'm trying to be flexible here.
Yeah, well, you know. You guys have no idea this is gonna be something.
See, you know,
No,
but
you-
you know I am.
Every case has never been easy with you.
But now you know good and well that is not true. We have worked through this and gonna work through this one as well. With no problems, hopefully. I know, you said I can't say that with a straight face, right?
We're working through. All right. Do you want the 4th or the 18th?
That's the 4th is fine.
We'll be here.
Yeah, there's no reason for you to be here, Mr. Bowling. Adjourn this out to March 4th, 2026, 9 a.m.
Thank you, sir.
And in all seriousness, Ms. Johnson, I hope that you're doing well.
I am. God bless you as well. All right, thank you.
Court does call the case, People versus Francis Judge.
Morning, Your Honor. Raymond Cook with people.
Ready, Judge. Court shall please to Assistant Public Defender on behalf of Mr. Judge. Mr. Judge.
Hello, I'm Francis Judge.
Thank you, sir.
Thank you, Judge. Do you have a copy of Mr. Judge's driving record?
Do I?
Yes, Judge.
Yes.
Mr. Judge has indicated and provided the receipt that he paid his fees yesterday and he should be valid. I don't know if you.
Oh, so you just did it yesterday?
Well, yesterday I got my license. Yeah. It says it right on there.
That's not what mine says.
Well, that.
But you did that yesterday?
I was at the secretary.
Nothing like waiting till the last minute.
Well,
Ms. Ann, can you, all right.
took a while to pay
I know.
that financial obligation. I know it's been a long
Something on
time.
my face says, talk to me. No, just, hang on a second. We're just gonna, this was run a couple days ago, so if you did it yesterday, it's gonna show suspended, but. Hang on.
He's checking.
Hold on, we're checking. No, I believe you. Put your wallet away. It's valid. Okay, you're valid.
Your Honor, people need to dismiss.
No objection, Judge.
Case is dismissed. All right.
I want to thank you for your patience and your understanding. Thank you, Judge.
You're more than welcome, sir.
Thank you.
All right, good luck. Drive safely, please.
Thank you.
Thank you.
Thank
Good
you.
luck to you. Yes, sir. Thank you, Judge.
You started this morning. Court does call the case, People versus Alicia, is it Calloway?
Yes.
Huh. Okay. Ready, Judge. Court shall please to Assistant Public Defender on behalf of the defendant. Please state your name for the record, ma'am.
Alicia Calloway.
Thank you. Judge, we did not have good contact information for Ms. Calloway. I'd be asking for an adjournment, and I'd ask Ms. Calloway to please call our office so we can make sure we have good contact information for her.
I have
adjourn the
called
matter,
the
March.
office.
Thank you.
You already did?
Yes.
Okay. March 4th, 2026, 9 a.m.
Thank you, Judge.
All right. Thank you, ma'am.
Thank you.
Court does call the case, People versus Noman Khan.
Raymond Cook with the people.
Ready, Judge. Court shall please to Assistant Public Defender on behalf of Mr. Khan. Mr. Khan, please state your name for the record.
Noman Rahman Khan.
Thank you, Judge. I've been in touch with Mr. Khan pretty much every day by text message. We're still trying to negotiate a resolution. I've reached out to Mr. Cook and I think he's considering it. I'd ask for a brief adjournment for his.
The last time we adjourned this, I said it was the last
Oh.
adjournment.
Okay.
I'll set it for jury selection and final settlement conference.
Sounds good, Judge.
Jury final settlement conference will be April 10th, 2026. 9 a.m. Jury selection if necessary, April 13th, 2026.
Thank you, Judge.
8:30.
Thank you very much.
Those are both in-person proceedings. Bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Were we ready on the roll call?
Yes, I was.
Recalls case, People versus Ricky Burdett.
Morning again, Raymond Cook with the people.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Burnett, who is approaching No.
Your name again, sir?
Ricky Burdette.
All right. I've been handed a plea form executed by the parties indicating that he will be pleading to count 2 of trespassing. The 30-day offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Is that correct, counsel?
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Ricky Burdette.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of trespassing. That is a misdemeanor punishable by up to 30 days incarceration and up to a $250 fine plus court costs. Do you understand that, sir?
Yeah, yes, Your Honor.
All right.
May I repeat that, please? That is both 30 days probation and $250 fine?
No, the maximum penalty on the charge would be up to 30 days in jail.
Oh, jail.
Or a $250 fine plus court costs. You understand that, sir?
Which am I getting? I'm not clear on what I'm getting.
I haven't decided on that yet.
I see.
Okay, but you understand what the maximum penalties are?
Your Honor.
All right. And understanding that, do you still wish to plead guilty?
I do.
All right. And to that charge, how do you plead? Guilty or not guilty?
To that judgment? Guilty.
Well, to the charge of trespassing, how do you plead?
Guilty.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Have you executed an advice of rights form? I don't see one. Counsel, did you go through an advice of rights form with him?
I did, Your Honor. And for the record, Mr. Bennett, those are the rights, your trial rights that you would be waiving here by accepting this plea. Do you remember that?
You remember that? Your attorney said that he went through your trial rights with you.
Yeah, yes, he did.
Okay. And that those were your rights, that the trial rights that you'd be waiving. You remember that?
Yes, I do.
All right. Look on the podium there. If you look on the podium, right here, right there where my bailiff's pointing, that's a copy of the advice of rights form. I'll let you get your glasses.
All right.
All right. And if you look at paragraph 5, those are your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
All right. You understand you're waiving your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation?
No, I'm not.
No, okay. Are you on parole?
No, I'm not.
Your Honor. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they have not.
Has anybody threatened you or coerced you in any way?
Say again?
Has anybody threatened you in any way to get you to plead to this charge?
No, they have not, Your Honor.
All right. You're doing this voluntarily and of your own free will?
Yes, I am, Your Honor.
And you're doing it because you believe that you are guilty of this offense?
Yes, Your Honor.
All right. On the date of January 15, 2026, location of 3153 Ann Arbor Saline Road in Pittsfield Township, that being Buddy's Pizza. What'd you do? Had you gone to Buddy's Pizza that day?
Since then?
No, on that date, back in January.
January 15th? Yes, I did.
Did they ask you to leave the premises?
Yes, they did, Your Honor.
Did you immediately leave the premises?
I left the premises after asking if I could question what I was being accused of.
Okay. So you did not immediately depart from the premises? I mean, at some point you left, right?
Yes, I did. After I was able to challenge or ask what I was being accused of.
Okay.
I was accused of threatening people, and I asked if I could repeat what happened the time I was there prior to, and go through to see if indeed that was threatening people. And then the manager that initially said that I was threatening people said, well, you were not threatening people. You were loud and you were scaring people. And so he changed his mind on that. And then I did leave at that point.
Your Honor, with the court and defense counsel's permission, may I voir dire for the factual basis?
I could voir dire as well. I was going to say the same thing, but he can voir dire.
Whoever wants to do it, go ahead.
I'll do it. I appreciate that, Mr. Cook. And Mr. Burdett, after you left, did you then return back in after being told you were being trespassed?
He said, did you, after you left, did you come back that same day?
Yes, I did. I walked out of the building onto the sidewalk, and I immediately returned to the building, and I immediately walked back to the bar and approached that same manager.
Okay, so just so that I have it right, okay? Because I have to make sure that there's been a crime committed.
Yes.
Whatever the dispute was, you were asked to leave Buddy's Pizza at some point, right?
Yes, Your Honor. I will.
All right. You did leave. Well, let me back up. You were asked to leave and did not come back, right?
Correct. Yes, Your Honor.
Then you did leave, right?
Yes, I did, Your Honor.
But then you came back.
Yes, I did, Your Honor.
Gotcha. All right. Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Absolutely, yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Sir, is there anything you want to say before I impose sentence?
Say or ask?
Whatever.
Can I ask a question before I am finally dismissed? I want to be clear on, after the judgment, I want to be clear on it.
On what?
Your Honor, I believe
if I'm getting probation after I serve the probation, am I free to leave the USA? I have an international passport. I just want to be clear on that.
I'm not going to put you on probation.
Just a fine?
That's what I was thinking. Do I need to put you on probation?
I don't even know if you've delivered the sentence to tell
I haven't yet, but I after listening to it, I don't know why I would put you on probation.
Oh, I was going by.
On doing something
I was
else?
going by that sheet on signed. I don't know if that meant both or just either or.
Oh, it's either or.
Either or, okay.
Okay, so I can put you on probation. I could send you to jail, or I could just impose a fine. So you want me to put you on probation? What are you telling me you want me to do?
Not necessarily.
Okay, I'm just trying to make everybody happy.
Sure.
All right.
I just, yeah.
Sir, are you gonna, the last time you were in here, you remember yelling at me? You don't remember that. That's okay.
Oh, trying to defend myself?
I don't know what you were doing.
Without counsel?
Well, right. Well, your attorney hadn't shown up.
Yeah.
And remember you were getting angry with me, and I was saying, I got to make sure your rights are protected, but you didn't like that for a moment. Remember that? Okay.
Yes, Your Honor.
So as I'm listening to you, I also realize, I think you're an Army veteran, right?
Navy.
That's right, Navy, because I said I liked you
Your
because
Honor,
you're Navy.
my other
right?
client was the Army veteran, Your Honor.
Your other client was Army, the one I didn't like. Okay, yeah, you're Navy. All right. And so, I realize that you're upset because things weren't happening the way they were supposed to. And also, I got the impression once your attorney, somebody got here for you, you calmed down and you seemed to me to be a man of your word. That's how I viewed it. Okay. And so as I listened to this plea, I also realized that you're one to always want to make sure that the right thing's done. Am I right? Am I right about all?
Yes, Your Honor.
Okay. And so I don't think that I need to put you on probation. You realize you're not supposed to go back to Buddy's Pizza, right?
Ever. Correct.
Exactly.
Indeed. No,
And
that's completely fine with me.
I'm going to trust you that you're a man of your word and that you're not going to go back there. I don't think I have to put you on probation to make sure you won't go back there. So I was just going to impose a fine unless you want me to put you on probation and send you to jail. If you want me to, I mean, I can do that, but I don't think you want me to. Right?
I'll pass.
Okay.
Yes, Your Honor. Yes. So can I pay the fine leaving the building today?
Absolutely. We will be more than happy to take your money. Okay.
Was my question about you using my international passport? Did that make sense?
You asked if you can then travel. Once I finish here, the world's yours. All right?
Thank you, Your Honor. Yes.
You're welcome. Let me ask you this, sir. You're not working, right?
I'm retired. No, I'm not working.
You're
Correct.
not working. You just received retirement.
Pardon?
You receive a retirement?
Yes, I do.
Oh. Fines and costs of $150. And I'll suspend 30 days in jail. You can get that paid today?
Yes, Your Honor.
All right. You can pay it up at the front counter. All right. Thank you, sir. Pleasure meeting you. You
Thank
take
you, Your
care of
Honor.
yourself. All right.
Thank you, Your Honor. Have a great rest of your day. I appreciate you greatly.
You do the same, sir. All right. Hey, fella, sir, it's going to take us a minute to get the file up there, so don't get mad at the clerks if it's not there. Yep. We'll race you up the hall. All right. Take care. Court is standing in recess and we'll come back and start our next block. All right. Sorry.
Good.
All right, please accepted. 150 is your total, and I'll have him pay this by the 25th, okay?
Very good.
Have a good day. Thank you.
Thanks, Judge. You too. Good to see you. Take care.
John Abu Chol, 26W84135A. Good morning, Mr. Jadala.
Good morning, Your Honor. Sam Richardala, P62186, appearing on behalf of Mr. Chol.
All right, so this is going to be a plea to impeding with the prohibited truck route to be dismissed, true?
Correct, Your Honor.
To that, and you're authorizing that plea on his behalf, true?
That is correct, Your Honor.
And to that charge of impeding, responsible or not responsible?
Responsible, Your Honor.
All right, I'm gonna accept the plea to impeding, dismiss the prohibited truck route. Fines and costs are $225, and I'll give them till the 25th to pay that, okay?
Thank you, Judge. May you and your staff have a wonderful day.
You too, thanks a lot.
Absolutely.
All right, Watson. Randall Patrick Watson, 26W841071A and B. Your name, sir?
Randall Watson.
All right. Jeez. All right, so this can be a no contest plea. I'm not sure what he's doing here. It looks like it's a no contest plea to resist and obstruct an officer based on, here, can you mark that, please? Based upon your level of intoxication, he's going to dismiss the disorderly person. Is that true?
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand a no contest plea has the same effect as a guilty plea.
Yes,
And
sir.
if you plead no contest to resist and obstruct an officer, I'm going to go ahead and dismiss the disorderly conduct charge. Do you understand that?
Yes, sir.
And a no contest plea has the same effect as a guilty plea. If you plead no contest, possible penalties to resist and obstruct an officer are up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
And you remember the rights I covered with you at your arraignment, right?
Yes, sir.
If you plead no contest, you're giving up the right to remain silent. You're waiving your right to a trial. You're waiving your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead no contest, you'll be giving up all those rights.
Yes, sir.
Hang on one second. He's got the wrong police report in here. Jeez. I don't know what in the hell is going on. Hello?
Yes, sir. I'm still here.
I don't know what's going on with it here. Can you call over to Mr. Urick or whoever's in there? And I need the police report on Watson. The one that you marked is not the correct. They put it in the wrong file. This is not.
Which room?
Wait a minute. Hang on one second. I do. Yeah, I need Mr. Urick. I need the police report on Randall Watson. You guys got a couple different guys in here or something. Oh, wait a minute. What is? Hang on a second. Is it just a one-page report, maybe? You got arrestees listed as a James Kareem Williams and Gregory Thomas Marshall. And then they've got the all right, I think it's just a one-page report. You guys gave me the 3 pages and the other 2 belong to somebody else. Here, let me take this. You're going to have to remove this exhibit sticker. And then that can go on this one or else I need another one. I'm so sorry, Mr. Watson. If you plead no contest, you're giving up your right to a trial. You're giving up your right to remain silent. You're giving up your right to testify or remain silent. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving the presumption of innocence. And it has the same effect as a guilty plea, like I told you. Do you understand that?
Yes, sir. Perfectly fine with all of it.
And you stipulate I can use the police report to establish a factual basis here.
Okay.
So I've had that marked Peoples 1 to the charge, resist and obstruct an officer. How do you plead? No contest?
No contest.
I'm going to review the report. All right. Are you on probation or parole?
No, sir.
Anybody force you to plead no contest?
No, sir.
I'll accept the plea of no contest. They're recommending fines and costs only. Please accept of no contest to R and O. Dismiss the disorderly public intox. I'm ready for sentencing. Is there anything you'd like to tell me?
No, just I apologize to the arresting officer.
Have you gotten in trouble because of your drinking before?
Yes, sir. Previously in the past.
Do you have any drunk driving citations, convictions?
20 years ago.
When's the last time you had an episode of where you were arrested because you were intoxicated prior to this January 22 of 26 incident?
I would say 8 or 9 years ago.
All right. Okay, I'm going to go ahead and sentence you, but if you have something else to say,
The only thing I have to say is I apologize to the arresting officer, just in general, and to the Buffalo Wild Wings staff.
100 fines, 225 costs, 75 victims' rights, $50 justice assessment, 450 or 90 days. Can you pay that today?
Yes, sir. I can pay it right now.
You can go on 33court.com, and that's with the B case number, because I've dismissed the disorderly public intox. Okay?
All righty.
You're all set. Have a good day. Good luck to you.
Thank you, sir. Thank you.
Do I have Dino Sankateris out there?
Yes, Judge, I'll bring him in right now.
Okay.
Dino, are you out there?
I'm here, Your Honor. Good morning.
Okay, start your video and I'll call these cases. Ronald Ray Henderson II, 26I-723-6772.
Looking for Julie. She might have come this way.
I'm confused.
Your Honor, they're two separate complaints. They're co-defendants, they're husband and wife.
I can see that. Heather, I need to send these back down, I think. They've got two files for Ronald Henderson, but they made two registers of actions with his name on it on the same file, and they made two registers of actions with Gina Henderson's name on it on the 771 file. Each of these files, what's the difference between the two, Detective?
There's no difference. They're married, they have children in common.
No, I get all that, but why do I have, I'm not I got to be honest with you, I'm completely lost here. It looks like you've got Point is, you got two offense dates that list 9/6/22 to March 5. Why do I don't understand why I've got two files here. Why do I have two files? They're the same episode, right?
Yes, sir.
Why do I have two files? Why do I have two co-defendants on two different files when they allege the same date? I'm lost.
That I can't answer, Your Honor.
Well, I can't either. Heather, I'm going to send this back down to you. You can take a look at it. We'll call you back. I don't know why. I must be missing something here.
I'll have Kim look at it. She's the one who puts those together.
And I could be missing something. To be honest, I just don't know why I have two registers of actions with the same number on them. Just take a look. And Dino, we'll text you back, okay? Sorry about this.
No worries.
All right. Give me run those when you get a chance. Davis.
Yes.
People against Ralph Otis Davis, 267-841-234 A and B. Mr. Gates, which case do you have? John, pull it out. Will you find out which one it is and pull it out for me?
Morning, Your Honor, Mike Hillcock, representing Mr. Davis. Mr. Davis, station A for the record.
Ralph Otis Davis.
All right, so what are we doing on this? He's going to.
Prepared for the arraignment, Your Honor, stand, meet, wait for the charges.
Yeah, I actually already arraigned him.
Okay.
And then, so he's going to plead to no ops on the suspend charge, right?
Correct.
The suspend's going to be dismissed. And also he's going to plead to drug paraphernalia. And the improper plate will be dismissed.
Correct.
Right?
Yes, Your Honor.
Is that what you want to do?
Yes, sir.
If you plead guilty to no ops, possible penalties are up to 100 fines, 90 days jail. Costs are all those. If you plead to possession of drug paraphernalia, the possible penalties are up to 500 fines, 90 days jail. Costs for all of those penalties. Do you understand that?
Yes, sir.
And did you understand all your rights on the advice of rights that you signed?
Yes, sir.
If you plead guilty to those two charges, I'm going to dismiss the suspend and dismiss the improper plate. The conviction will be entered for no ops. The conviction will be entered for drug paraphernalia. You understand that?
Yes, I do, Your Honor.
All right. So any questions on your rights? To the charge, no valid operator's license on person. How do you plead? To the charge of no valid operator's license on your person, how do you plead?
I mean, because I stand me to say it.
Hang on a second. Slow down.
You going so fast, I'm coming.
All right.
Pleading guilty to it.
All right. Maybe I am going too fast.
Yeah.
My apologies. I'll slow down. To the charge of no valid operator's license on person, how do you plead?
Guilty.
To the charge possession of drug paraphernalia, how do you plead?
Guilty.
Were you operating a motor vehicle on Allendale West in Woodhaven, January 7 to 26 at 11:55 p.m.?
Yes, sir.
Did you have a valid license on your person?
No,
Were you in possession of drug paraphernalia? And if so, where was it? Was it yours? And what kind of drug paraphernalia?
it was mine. It was in my pocket.
And what was it?
After it was a glass stem.
I can't hear you.
A glass stem.
Okay, and you use that for what purpose?
You wouldn't believe it if I told you.
I need to know. Tell me.
I used to smoke tobacco. I'm gonna fix it, but they said it's there from that, so I'm taking it for charge. I'm gonna fix it. But that's the truth.
Did you use it for any other purpose?
No,
Smoking crack?
no. I had no drugs on me.
I didn't ask you that.
I didn't,
Well, I can't. A hard time accepting a plea if he's not acknowledging he used it for drugs. You never use that for drugs?
not that.
I can't hear you.
No, not what they found on me, no. What they
All
found.
right, well,
Can we work on this?
yeah, we'll pass that. We'll pass that case. I'm gonna take Mr. Gate and get him out of here. Which case do you have?
Single judge.
People against Lori Gay Hinkle, 26W841130A and B.
Good morning, Judge. Has been given her back from the Supreme Court.
Your name, ma'am?
Well,
All right, counsel, for purposes of,
We'll send you where
all right, and now she's going to plead to operating while visibly impaired. The super drunk will be dismissed. And she's also going to plead to,
the B charge of dismissal.
okay, and then they're dismissing the improper lane use as well, correct?
Yes.
If you plead to impaired, ma'am, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service costs, or all of those. 4 points, license suspension, revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, I do.
And did you sign an advice of rights form here today and read it and understand it?
Yes, I do.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Guilty.
No.
I didn't ask you that.
Understand, when you show a plea, that you're giving up the rights, and the advice of rights.
Do you understand what I said? Do you?
Well,
If you plead guilty to operating work while impaired, you're giving up all the rights on this advice of rights form and we're not going to have a trial. Do you understand that?
yes,
All right. Is that what you want to do?
yes,
To the charge operating while visibly impaired, how do you wish to plead?
guilty.
Were you operating a motor vehicle on Van Horn near Hall Road in the city of Flat Rock? I'm sorry, in the city of Woodhaven on January 5 of 26.
Yes,
Prior to driving that vehicle, operating that vehicle, did you consume alcohol?
yes.
What did you drink and how much?
I was drinking beer, and
How many beers?
about 2 to 3 beers, always.
Regular beer?
Well, it was ice. It was ice beer and a lot of water content. So
Okay, slow down. Keep your voice up. I didn't hear a word you said. How much did you drink?
about 2 to 3 beers.
And what kind of beers were they?
They were ice beers.
I don't know what a nice beer is. How big was the beer?
It's just a little bit bigger than a 12.
So like a 16 ounce?
It was 4.
They call it a tall boy, Judge.
All right, so 24 ounce, you had 2 of them? I'm sorry?
2 to 3.
2 to 3, maybe 3 or 4? No?
No,
And then you operated the vehicle, right?
yes,
And was your ability to operate that motor vehicle impaired because of the consumption of the alcohol? And if so, in what way?
yes. I was swerving.
You think you were swerving at least in part because of your alcohol consumption?
Yes,
Did you take a breathalyzer test or a blood test?
yes,
Which?
Did a rough one.
All right, an intoxilizer test. And were the results of that 0.166?
yes.
Actually, Judge, that was the PBT. The breathalyzer came in at 0.21.
Okay, and you stipulate that the 2-1 reading was an accurate reading for purposes of the plea?
Yes.
Are you on probation or parole, ma'am?
No,
Anybody in the world force you to plead guilty?
no,
Plea is accepted to that charge. I find it to be an accurate plea, made voluntarily and understandingly. The plea is accepted. To impaired driving, I'm dismissing on motion to prosecutor the improper lane use and the operating while it's actually a super drunk charge, so I'll dismiss that. Motion to prosecutor. I'm going to order a screening and assessment, and I'm going to set a bond. I'm going to set a $1,000 personal bond. I am mindful of the fact that you showed up to court drunk. That tells me that somebody has a problem. I'm going to order, she showed up to court the last time drunk. I couldn't even arraign her because she had a 166. That's why I read that. I forgot about that being the result on the previous PBT. No contact with prosecution witnesses. I want you going to AANA 3 times a week. We're gonna hand you a form. You have to go in person. Every time you go, you have to have the form signed. No alcohol, no illegal drugs, no marijuana. And you are to be on a SoberLink device by the end of the day. That's a breathalyzer machine, essentially, ma'am. Probation's going to explain it to you. You're going to be on, ma'am, I want you to listen to me. You're going to go out to Macomb today or Macomb County and get a SoberLink, and you have to do it by the end of the day. You understand me? Yes?
Yes.
AA 3 times a week in person. You understand that?
Yes. May I add something?
Sure.
I am on the list for Oakdale to go into alcohol residential.
Well, that's great. But you're going to, in the meantime, you're going to get this SoberLink device, and I'm going to expect to be blown in that machine until I change the bond. Okay? Give me a screening and sentencing date, and you're going to go next door, probation, fill out a questionnaire and be interviewed. We'll give you a sentence date. If you're still in Oakdale, we can do it on Zoom. So you'll have to stay in touch with this, okay? Or I could set this out 4 weeks if you want, Heather.
We could do that, Judge. If you want to go to the 18th, we could do it at 8:30.
March, what? 18th?
18th, yes.
At 8:30. That will be your sentencing date. Do you fully understand everything I've just said?
It's a lot to,
No alcohol, no drugs, no marijuana. You're going to AA 3 times a week in person. You're going to go figure out where you're going to go. Probation's going to explain it to you. Listen, you're going to get a SoberLink device. You have to be on a SoberLink device that you are blowing into by the end of the day. Do we understand one another? Do you understand?
Right.
Yes?
Yeah.
And no contact with prosecution witnesses. So you go down the hall, get your notice, go over to probation. They'll explain where you have to go to get your SoberLink, okay?
And Judge, I'm also printing up a register, and it will have everything she needs to do on there, and I will highlight it for her so she understands it.
Thank you.
You can go to probation when she comes here, you can go to the social.
Are you all right? You all right?
Yeah, I'm just nervous.
All right. I mean, you have a reason to be nervous after showing up drunk last time. Do I have He Neely here? Okay, I gotta wait for your lawyer. Do I have Kleiber here? Kate Kleiber, come on up here, man. Kate Jean Kleiber, 26W841356B. Your name? The A file. Did you go into default on that? What happened with the A file? Are you her spouse?
Yes.
Yes.
Okay, I'll let you stand there, but I can't let you represent her in any way. Okay, do you want to tell me your name?
My name's Bruce Kleiber.
Okay, I understand. Just give me. Okay. Just give me 1 second. Heather, can you check on the A file? It's not in the jacket. You're charged with improper play. That is punishable by up to 100 fines, 90 days jail, costs, or all those. I can send you to a lawyer to represent you, or I can arraign you and send you to the prosecutor. Do you understand that?
Yes.
You want a lawyer, or you want me to arraign you and you go to the prosecutor?
I guess I'd like a lawyer.
Okay. We'll set you up with a lawyer. Go out in the hallway and we'll set you up with a lawyer, okay? Mr. Crawford, you ready on yours, sir?
Ready.
Judge,
What? Do you have the files on the last gentleman?
Still working that out.
I'm sorry, Heather, what were you gonna say?
that was on Kate Kleiber, you said?
Yes.
Yes, the aid distracted driving was paid.
Oh, that was paid. Okay, so good enough. So tell your lawyer that. Which one do you want me to call? Donald Earl Hudson? 25W838585B.
Morning, Your Honor. I feel proper representing Mr. Hudson, who's approaching.
I don't know why he's here. He was supposed to pay 30 per week, bi-weekly, beginning in October the 8th. He blew it off, huh?
Well, you can blow it off, Your Honor. He simply does not have the money. My client essentially on the house, he bounces back and forth between the relative home and the Detroit rescue mission, Your Honor. He doesn't work. He's applied for disability. He's waiting on that. He relies upon family and friends, Your Honor. May we suggest we do community service as an alternative? You can find that, put in those hours.
Yeah, I can do that for him. If you're, he owes $525. Your name again, sir?
What's your name?
Donald Hurst. Donald Earl Hurst.
All right, let me think this through. You served 40 hours of community service for pay $525 by April the 15th. So you do 40 hours of community service by April 15th, provide us proof, and I'll be happy to dismiss this. Okay?
He says the proof of probation?
Yeah, he's going to send the proof to probation. And why don't you go talk to them? They'll explain it a little more in depth to you, okay? Good luck. Guy Neely. People against Jacob Guy Neely, 2-5-W-839-903-A and B. Your name, sir?
Jacob G. Neal.
Mr.
Michael Walker, Reverend Engineer.
So he's going to plead to no ops on file B, right?
Yes, ma'am.
The suspend will be dismissed in the false ID, right?
Correct.
Is that what you want to do, Mr. Guy Neely?
Yes, sir.
If you plead to no ops, possible penalties are up to 100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes.
And did you sign an advice or rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we will not have a trial. Do you understand that?
Yes, sir.
To the charge of no valid operator's license on your person, how do you plead?
You.
Were you operating a motor vehicle on June 10 of 25 in the city of Woodhaven, County of Wayne on Allen near Carter?
Yes.
Do you have a valid license with you on your person?
No, sir.
Are you on probation?
No, sir.
Parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to no ops. I'm dismissing the false ID and suspend on motion of the prosecutor. All right. He's going to be more respectful in the future, right? Not by not, he's going to show up on time and all that, Mr. Geeney, right?
Yes.
Where do you work at again?
I mean, beats.
You what?
Make beats.
Beats? All right, I'll let it go. Yeah. Go ahead. Go ahead. What do you have to say, Mr. Crawford?
He understands he's got an uphill road in terms of getting his driver's license, but he's a little bit of the terrain. He knows he's got a couple matters. He knows the courts. He's reached out and made contact. He's going to do what he needs to do to get in order. He needs to be able to drive, take care of his young family, and continue to make beats.
Anything else?
No, sir.
Hard fine, 70 costs. 75 victims' rights, $50 justice assessment, $295 or 60 days. Can you pay that now?
I think I can pay that today. Could you give me February 23rd, Monday?
Can you pay by then? In full?
Judge, we do have him on a payment plan with multiple cases. I don't know if we want to just put this one in with those.
Tell you what, you want to set this payment plan up for me, Heather?
Yeah, we can just roll this in with his payment plan.
So you go down the hall and they'll set it up with the other payment plans. But stick with them. If you need more time, you call the court. We'll go on Zoom. I'll give you an extension. Don't ignore it, right?
Yeah.
Thank you. Let's go right down the end of the hall. Counsel, do you have, oh boy, Dolores Griselda Vasquez Vales. We need an interpreter on this one, right?
That's one of the courtroom.
Oh, you're the interpreter. What a great country. Thanks. Come on up here. All right. Come on, ma'am. How are you? Hola. Hola, ¿qué tal? That's the last thing I remember from Spanish class. All right. What is your name?
Shalonda Heisley, HEISLEY.
Thank you very much. I'm going to ask you to raise your right hand. Do you solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant?
Yes, sir.
All right. Can you state your name, ma'am? You are charged with retail fraud. You have the right to a lawyer. If you would like one, I will set you up with one right now. Would you like a lawyer?
No.
Okay, I'm going to go ahead and arraign you. And then I'll send you to the prosecutor. And let me call up Travis Shatima. You can speak English, right?
Yes, sir.
Come on up here. This is file 26W841324. Your name, sir.
Travis Shatima.
All right. I'm going to go ahead and arraign you unless you want a lawyer. Do you want a lawyer?
It's fine.
On February the 2nd of 26, it is alleged that both of you did commit the offense of retail fraud at 23800 Allen Road in the city of Woodhaven. That is a misdemeanor. It is punishable by up to $500 in fines, 90 days jail, court costs, or all of those. Do you understand that, sir?
Yes, sir.
Do you understand that, ma'am?
Yes.
All right. Did you read the advice of rights form, Mr. Shatima?
I did, yes, sir.
Did you understand it?
Yes, sir.
Ms. Vasquez Valles, did you read the advice of rights? Or did the interpreter read it to you, I should say?
Yes.
Did you understand those rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that, ma'am?
Yes.
Sir, do you understand that if you plead guilty, we're not going to have a trial?
Yes, sir.
I'm going to enter a not guilty plea for both of you. I'm going to give you both a personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to give you a personal bond. I'm going to send you to the prosecutor, and we'll see you back here in a few minutes. I'm going to take a quick recess. Thank you.
You worked at your age here.
Court does call the case, people versus really Joshua Wara.
People.
Good morning, Judge. Lawrence Margolis with and on behalf of Mr. Wara, who is approaching. Josh, please state your name, Judge.
Joshua Wara.
Thank you, sir.
Judge, I am recently substituted into this matter. It is the day.
State of Ohio, Ms. Tranter.
Your Honor, it's my understanding that Mr. Wise is prepared to change his plea this morning. He will be pleading guilty to the one count of the indictment, aggravated possession of drugs as a felony of the 5th degree.
All right, Ms. Chambers, is that accurate?
Yes, Your Honor.
All right, Mr. Wise, they're telling me that you're going to change your plea to guilty to one count from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Sir,
How old are you?
37.
How far did you go in school?
Got my GED.
Can you read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead your change your plea?
No, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what we're doing?
No, sir.
All right. I have in front of me a document called a change of plea. On the second page of this document, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Ms. Chambers?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the 5th degree that carries a maximum penalty of 12 months in prison, a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
Now, on this, you are also subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate their rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Ms. Chambers, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
Now, the burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charges from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
You understand that when you enter plea of guilty, you will be waiving all these rights. We're not going to have a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
All right, Ms. Tranter.
On or about May the 17th of 2025, Warren County, State of Ohio, the defendant, Alexander Wise, did knowingly possess a scheduled substance, specifically being methamphetamine, a Schedule II, in an amount of that was less than 0.1 grams.
Ms. Chambers, anything on those facts?
No, Your Honor.
Mr. Wise, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we discussed.
Yes, sir.
And what is your plea?
Guilty.
The court will make a finding that you have made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, and we'll come back in a few weeks and do sentencing at that time. This is an older case, right?
It's not that old, Your Honor.
When was he indicted?
He was indicted, it looks like back in August of 25. And then he had, well, it is older because it happened in May. Looks like he was out on bond. There was a order revoking bond in KPS issued in June. The lab must have still been pending, and then he was indicted in August.
Okay. All right, somebody be in contact with you, Mr. Weiss, at the jail to do the pre-sentence investigation.
Your Honor, if I may, he does have a bed available at Modern Psychiatry. They have screened him already and found him appropriate. He did want me to advocate that he be released to that program if his pretrial services officer thought that was appropriate. Even while this pre-sentence investigation is ongoing, he understands he may have to be on a monitor. He's okay with that, but he did want to advocate that he get released to a program as soon as possible.
Ms. Tranter?
Judge, I'm not familiar with that program, so I really would probably feel better at this point if we had the assessment done and get the recommendation from pretrial.
When was the last time you were in treatment, Mr. Wise?
I've never been in treatment, sir.
Well, looks like that's not true.
Oh, was the CCC program considered treatment?
Yes, it is.
I'm sorry, I don't know these things. I wasn't paying attention.
You were in CCC and you were unsuccessfully terminated from that program back in 2018. Is that right?
Yes, sir. Due to a disagreement between me and another client that was in there, I got dismissed 2 weeks from graduation.
This looks like in Shelby County. Oh, that was quite a while ago, 2007.
Yeah.
Looks like you completed some sort of treatment then as well.
Oh, that was in the jail. It was some kind of anger management program, I believe is what it was.
All right, I will have court services look into this, and then I'll give you, I'll let you guys know, okay?
Thank you.
All right. Yes, please. Kaylee?
Yes.
If you get a chance when you come back, when you're done with your.
In time for a pretrial. The prosecutor has informed me that there are there's one new charge, a misdemeanor coming out of 14B that has not been, has it been set for arraignment?
Yes, so he has it's not a new OWI, it was recently charged. He has an OWI set for arraignment on March 24th out of 14B. He also has a felony matter set for April 2nd for a competency review. I believe we're just asking for an adjournment. We're trying to push out the arraignment on his 14B matter so we can get arraigned on that. We can do a global resolution with all three of these cases.
All right.
Correct.
The 18th would work, you think, or?
Hopefully,
March, Judge.
I'm not familiar with 14B's policies. I'm moving up arraignment dates, but I'm going to try and get that worked out. So we will try and make the 18th work.
And I'd also let your office know of, I believe the competency report has concluded, or the evaluation was done. I believe he was found competent to proceed. I don't believe the report has been received yet. Have you received that yet, Mr. Cook?
On the felony matter?
Correct. And
I've received, he was found competent in this matter.
Yes.
So.
Okay.
I don't know why the same wouldn't occur in the.
And I agree, and we'll handle that and get that report to the court.
All right, very good. March 18th, 2026, 9 a.m.
Thank you, Judge.
On continue. Thank you. Court calls the case of the people versus Zachary Johnson.
All right, so on behalf of Cecil Township.
Brian Mulligan, on behalf of Mr. Johnson, Your Honor, can you state your name for the record?
Zachary Johnson.
Your Honor, we've resolved both of these matters. There should be an executed plea form in the file ending in 0618, where Mr. Johnson would plead guilty as charged to the failing to report an accident with fixtures. And with respect to case ending in 1025, Mr. Siller's been kind enough to offer a plea to double parking in that matter based on Mr. Johnson showing a valid driver's license. So he would plead responsible to double parking in that case.
That is correct, on behalf of the township.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Zachary Johnson.
Sir, it is this court's understanding and starting in case ending in 618 that you are going to be pleading guilty to the charge of failure to report an accident to fixtures at punishable by up to 90 days, $100 fine plus court cost. Do you understand that, sir?
Yes, sir.
Exactly. And to that charge, how do you plead, sir?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of it?
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
Yes, sir.
And because you believe that you are guilty of this offense?
I do.
February 29, 2024, at the location of South State Street near Runway Boulevard, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a Ford Focus?
I was.
And what happened?
I was on my way to do some Uber Eats, and I was going to stop at the Speedway over there, get some coffee. It was, late at night, and I just half dozed off for like 2 seconds and hit the curb, and it was chaotic after that. Totaled the car.
And did you hit a utility pole?
I did, yeah.
All right. And it damaged that utility pole?
It cut it in half. Yes, it did.
With a Focus?
Listen, man, that Focus saved my life, and I am lucky.
No, that's fine. I'm just thinking.
I don't know how it.
Think how better it would have been with a 150. Anyway, never mind. Not saying.
If the 150 might have survived, who knows, man?
All right. So, and after that, did you report that accident to the nearest and most convenient?
I did not. No.
All right. You didn't report it in any way?
No.
Correct. All right. Counsel, do you believe that I complied with the court rule? Would it be proper to accept this defendant's plea regarding that charge?
Yes, Your Honor.
And sir, on the date of July 1st, 2022, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, do you admit responsibility to double parking a motor vehicle?
I do.
All right, court will accept that admission. This is in case 1025. It will accept the admission to count 2. Count 1 is dismissed. In that case, there are fines and costs of $180. In your other case, is there anything you want to say before I do impose sentence?
No, sir.
Fines and costs of $250. When can you pay all of that? By next Friday? 27?
Yes, sir.
All right. Pay it by the February 27th in both matters. And in the case ending in 6/18, I'll suspend 90 days in jail.
Thank you.
Thank you.
Thank you, Your Honor.
Good luck. Take care, drive safe. Yes. Go ahead, boy. Court calls the case, People versus Devontae Connor Belcher.
Morning, Your Honor, Raymond.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Devontae Connor Belcher on one of the cases.
Attorney Chief for District Court Defender on behalf of Mr. Connor Belcher on the remaining files.
Sir, your name?
Devontae.
Thank you. What are we doing?
Your Honor,
Please.
So, Your Honor, Ben, I believe this is going to be signed with a plea form that should be in front of Your Honor in just a second. The essential nature of that plea is signed and part of the file ending in 10/7/22, 2001.
Hang on. 1782, he's going to be pleading on.
Within $1,194.39 restitution. In exchange, the people would be dismissing the files ending in 1243, 1112, 1234, and 1370.
So all the remaining files.
Correct.
All right, I have a plea form in front of me that indicates that the defendant would be pleading to the charge of retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, the case is referred to by the prosecutor will be dismissed, the other 4 matters. And he's also agreeing to pay restitution in the amount of $2174.39. That's the court's full understanding of the agreement.
My handwriting might be better. It's 2,194, not 74. My apologies.
Oh, that's a 9. So 219439.
Correct.
Pardon?
That is completely.
All right. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Devontae Connor Belcher.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
Negative.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal of right.
Mm-hmm.
Is that a yes?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
Negative.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes.
August 18, 2025. Location of 3145 Ann Arbor Saline Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Meyer that makes you think that you're guilty?
I walked into that Myers, grabbed sports cards and some sushi. and I walked out and did not pay for those products.
All right.
Yes.
So when you say sports cars, toy sports cars or strolled?
Sports cards, trading cards.
Oh, cards.
Yes, sir.
Gotcha. Okay, cards. And tried to walk out without paying for them.
Yes, sir. Sure.
All right. Was the amount that you attempted to walk out with in excess of $200?
Yes, sir.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to take that property, did you?
Negative. No, I did not.
And this property you took was property that was offered for sale by buyer?
Yes, it was.
All right. So I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Yeah, Your Honor.
It's on record, Judge.
All right. And have I complied with the court?
Yes, Your Honor. Yes.
Yeah, Judge.
All right. Court will accept the defendant's plea of guilty to that charge as contained in case ending in 1782. The case is ending in 1243, 1370, 1112, and 1234 are dismissed pursuant to that plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing will be All right. Yeah. March 11th, 2026, 9 a.m. Bond.
You have a lovely day, sir.
You do the same. Thank you.
Thank you, Judge.
Court calls the case of the people versus Matthew Wallace.
Your Honor, Raymond Cook for the people. County Auditor on behalf of the Township.
For the Judge Torshov Fees for Assistant Public Defender on behalf of, but I do not believe I am with Matthew Wallace. Matthew Wallace. Your Honor, we have not had any contact with Mr. Wallace. For the record, I will request an adjournment, but I do not know why he is not present.
And tomorrow we'll issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Thank you. Calls the case people versus Kristen Anthony.
Raymond Cook to the people.
I get the wrong one.
Brian Bowling, Assistant Public Defender on behalf of Ms. Anthony. Can you state your name for the record, please?
Kristen Nicole Anthony.
Judge, with respect to the pretrial, we're seeking an adjournment. It's my understanding Ms. Anthony is scheduled to see Judge Hammoud on the 23rd. So we'd like to come back after that date if at all possible.
23rd
of February. Yes, I'm sorry.
Adjourn this to March 4th, 2026, 9 a.m.
May I address bond?
You may.
Your Honor, Ms. Anthony would like to consider the court, or would like to ask the court to consider granting her a personal bond in this matter. She is 39 years old. She's a resident of Wayne. She is single, but has two children, a 10-year-old and a 12-year-old. And she's currently a student at Wayne State University studying business there, Your Honor. Ultimately, it's my understanding that the court granted a release to treatment on the other matter. So if we were unlikely to grant a PR bond in this case, we would ask the court to consider mirroring the release to treatment order in this matter to coincide with the other case.
Your Honor, I have no objection to release to treatment. For the record, looking at actually, I do out of county schools, including one person who's here on a tether detainer, looks like a county, a couple of retail frauds. She has 2 bond deniables. So I think that a PR bond would be appropriate, but release the treatment with tether, I think would be appropriate.
I will not change her bond in this case and give her personal recognizance. However, I have no problem signing an order for release to treatment with the GPS.
Wonderful. Thank you. Gunnar.
Thank you.
We'll be in touch with them.
Court does call the case People versus Ishmael Davis.
Morning, Your Honor, reading the code for people.
Registered Judge O'Keefe, the Assistant Public Defender on behalf of Ishmael Davis, who I do not believe is present, Your Honor. Mr. Davis, from our notes, was in custody. Apparently, he bonded out. He is not apparently in the courtroom today.
Based on my interaction with him before Judge Fresh Hours, that's my understanding.
Mr. Bowling has additional information, Judge. He believes Mr. Davis may be in inpatient treatment based on his other case in front of Judge Fresh Hours. So
What Bowling told you?
I'm just a parrot today, Judge.
So you want to be able to check that?
Yes, Judge.
On March 4th, 2026, 9 a.m. Defendant may be in treatment. If he's not, I'm locking up Bowling.
Fair enough, Judge.
Feaster didn't even try to protect. Court calls the case of the People versus DeJure Bond Sanders.
Morning, Your Honor, reading the code for people.
Ready again, Judge. Torsia, the Assistant Public Defender on behalf of DeShore Bond Sanders, who is approaching. Please state your name for the record, sir.
DeJure Bond Sanders.
Thank you, Judge. My understanding is Mr. Brown met with Mr. Bond Sanders yesterday. We're setting this matter, we're asking the court to set this matter for final settlement conference and jury trial. I believe Mr. Bond Sanders is going to personally request to dismiss this matter. I don't know that he completely understands how the procedure works, and maybe the help explain it to him. But he's requesting a dismissal. Assuming the court does not grant that, we'd be asking for a final settlement conference and jury selection, Your Honor.
You have something you want to say?
Yeah, I mean, since I've been having all of my my other ones in front of you, like they haven't been shown up to court, so I don't see why it would be the issue.
You know what?
On PR bond.
Why this wouldn't be a PR bond?
Because they haven't been shown up to court, and all my others have been getting dismissed as well.
It was probably because, when was this one? Was this one picked up while you were on bond on other cases?
I'm sorry?
Was this case picked up while you were on bond for any other cases?
I'm not sure.
Okay. I'll defer to the court, but from what I recall reading in the notes, Your Honor, I believe this started out as a felony. I believe it was reduced and remanded at exam as a result of the complaining witness not appearing. I believe Mr. Bond Sanders has a 100 bond in his file. I believe he is requesting that the court consider a personal bond after the court determines where the court's going to set this matter next.
Your Honor, the notes that I have from arraignment indicate that at the time of arraignment, EST was on bond 14G and was 9 case. Looks like, looking at Mrs. Zenda's notes, there were some issues with phone privileges at the jail for this defendant. I would ask Tom to continue. I think right now it's set at $1,000 cash and surety. Since he was quite for some sagging on that, there's a he gets excluded from tether of the entirety of Washtenaw County. I don't know if he has proof of that address.
My client does indicate he has proof of his address he would go to in his pocket here, Your Honor, if the court would consider the PR bond. He does indicate that he has permission and a valid place where he can go should the court decide to release him. Either on
I'm not going to release him. I'm not changing the bond in this case. His bond will continue. Jury final settlement conference will be set April 10, 2026 at 9 a.m. Jury selection will be set April 13, 2026. Seriously. At 8:30 a.m. Both of those proceedings are in person.
Thank you, Judge.
Thank you.
All right.
Courthouse case, People versus Shannon Kiesling.
Brian Bowling on behalf of Ms. Kiesling, Your Honor. Shannon, can you state your name for the record, please?
Shannon Kiesling.
Judge, Ms. Kiesling is scheduled to meet with Mr. Heaton for screening for the 14-day sobriety court program tomorrow.
Okay.
Yeah, so if we could get in.
March 4th.
Yeah, that's perfect. Thanks, Judge.
2026, 9 a.m. We'll continue.
Everything's at 9 and then it'll probably change. Okay. All right. I'll be in touch.
The court calls case of the People versus D'Amico Brown. Yeah.
Morning, Your Honor, Raymond.
Cummings, I'm sorry. I don't know why I said Brown.
Conrad Siller on behalf of Huntsville Township.
Cummings,
Cummings the second.
yes. Must have been thinking Ronald Brown.
All right, ready-ish, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Cummings. Please state your name for the record.
Good morning, D'Amico Cummings for the record.
Thank you.
Thank you, Judge. I'm looking at our docket. I don't see Mr. Cummings' name on the block. I don't know that he has been open noon. Okay. Looks like he has spoken to someone and that they will request an adjournment on the file for further negotiations.
March 4th, 2026, 9 a.m. Bound continue.
Thank you, Judge.
Yeah, we have an idea.
Court calls case People versus Carlos Mack.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Mack, who is approaching. When you arrive, please state your name for the record, sir.
Carlos Mack.
Thank you.
Thank you, Judge. This is a case I believe Mr. Mack is trying to get a valid license. He does indicate he needs the court's permission to pay a clearance fee. He's
here.
That's yes, sir.
That's all he needs to do.
That and another, he says another month, he should have his assessment completed and get his license back.
I know I got it today, but I get for my assessment, yeah.
So I guess he needs to pay the fee and he needs another month. If the court will adjourn it for a month, he thinks he could have it back after.
Okay, defendant may pay clearance fee. I'll adjourn this out to March 18, 2026, 9 a.m. That's the last adjournment.
Last adjournment.
Yeah.
All right.
Yeah.
Thank you. So you have to have it back by then. Or we're gonna
Thank you.
Thank you.
Thank you, Judge.
Court calls case People versus Michael Erickson.
Morning, Your Honor, Raymond Cook for the People.
Brian Bowling on behalf of Mr. Erickson.
Hello, Michael J. Erickson.
Your Honor, we're continuing to try to resolve this matter. It's my understanding Mr. Cook is looking into some restitution issues. So if we could get an adjourned pretrial date.
March 4th, 2026, 9 a.m. Bound continue.
May I address bond?
Sure.
Your Honor. He's asking to be, Mr. Erickson's asking to be released on a PR bond if the court would feel it was appropriate. Otherwise, we'd ask for a release for treatment and I can prepare a proposed order for that if the court was inclined.
I don't need a response. I will not reduce it to a personal cognizance. I'll leave the bond where it is. I will sign a release to treatment.
Wonderful. Thank you, Your Honor.
Thank you.
Let us know.
Court does call the case People versus Adam Martinez.
Brian Bowling on behalf of Mr. Martinez, just state your name for the record.
Adam Martinez.
Judge, we have a resolution in this matter. There's a proposed plea
form in front of me that indicates that he would be pleading as charged.
That's correct, Your Honor. Mr. Martinez has been screened for entrance into the 14-day sobriety court program, which he has been approved for. I know he was there last Thursday to observe that program and is asking the court to accept his plea, and ultimately, hopefully, that's where he'll be sentenced to.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God? State your name, please.
Adam Martinez.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. Is that correct?
Yes, sir.
That is a misdemeanor punishable by up to a $1,000 fine, up to 1 year in jail. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will? And also because you believe that you're guilty?
Yes, sir.
January 31st, 2024, at the location of Ellsworth near Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
Do you know how much you had and what you had?
I had a fifth of vodka.
Fifth of vodka?
I'm not sure how much I drank of it.
Okay. Were you stopped by the police or was there an accident?
It was an accident.
What happened?
I don't remember, to be honest. I just woke up in jail.
All right. Wow. We're gonna have a problem. So you had the accident, don't remember anything after the accident?
Not really sure, no.
Okay. I'm gonna stop the plea at this point. What I would do, counsel, if during my next break, so that we can get this gentleman moving, if somebody will provide my office police report, I'll take a no contest plea.
Wonderful, Judge. I have it right here. I'll send it to your staff.
All right. All right, so I'll call it up. You have to give me a chance to review it. Court calls the case People versus April Fleming.
Judge Portia Feaster, Assistant Public Defender, on behalf of Miss April Fleming, who is approaching the podium. Please stay.
State your name, ma'am.
April Fleming.
All right, what are we doing?
Terms of the case, Your Honor, I believe she met with Mr. Brown in custody yesterday. There is a plea resolution. I'm turning to the court, Your Honor.
All right, plea form indicates that she's going to plead guilty to the charge of retail fraud third degree, which is as charged. She's agreed to pay restitution in the amount of $65.62. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Judge.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
April Fleming.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
I'm sorry.
You're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
Date of June 17, 2025, location of Myers in Pittsfield Township. I think it's 3825. Yes, 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I put stuff in my purse.
And
Okay.
to take it.
Yes. Yes.
So you walked into the store, you put stuff in your purse, and tried to walk out?
I was grocery shopping too, but I stole some stuff too.
All right.
Yeah.
So the stuff in your purse, Was that stuff that was offered for sale by Meyer?
Grace, yes.
You didn't have anybody's permission to take that property, did you?
No,
And the store was open to the public at the time when you did this? All right. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Nothing, people.
It's on the record, Judge.
All right. And have I complied with the court rule?
Yes, Your Honor.
I believe you have, Judge.
All right, court will accept the defendant's plea of guilty to this charge.
Judge, I believe Mr. Brown wanted us to request the court consider immediate sentence.
What else does she have? I usually don't do it on these cases, but
My understanding is there's nothing else holding her. She's been in custody for 63 days.
there's nothing else holding her?
That's
Not that I see.
All right, so here's what I'll do. I'll refer the defendant to probation for pre-sentence investigation and report. And I understand the restitution has been set, but there's an issue regarding that. Sentencing in this matter will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. So nothing else is holding you?
no.
What's her bond in this case? What do we have?
Your Honor, bond was denied on this matter.
Yeah, that's right. All right. Ms. Fleming, what do you think my biggest worry if I let you out is?
Did I use drugs?
Yeah, but the drugs you're using,
Yes, in particular, are very dangerous. Very dangerous.
do you think that's my worry?
Yes,
On part. My worry is you won't come back. Not that you voluntarily won't come back, but that you'll be dead. That's what worries me.
I understand. I just thought that this would be, that I'd be home by now, you know. I didn't
No.
expect to be here 63 days later.
I didn't think I'd be holding you for 63 days. Right?
Sorry,
I didn't think I'd be holding you for 63 days.
I know.
So how are you going to not use?
Well, I'm gonna try to stay busy. And everyone in my whole circle, I mean, everyone was giving me ultimatums already. So, I mean, you said everything happens for a reason, and I am very grateful for the intervention. And I mean, if I were to pick that stuff up again, my dad will be gone, my fiance will be gone, everyone will be gone, and I'll probably be gone too. That's all I can tell you. I don't.
I got you. I mean, when it was actually interesting when you gave your admission to the court, because you really, usually a lot of people skirt around and to try to hide, to try to do you. It was almost like when you gave it, and you said this, where you were tired of doing that and you just admitted it.
Yeah.
You didn't know what was going to happen. You just said, yeah, that's what I was doing.
Yeah.
And I appreciated that. But now I got to figure out, because you're not going to be in it forever. It's clear, right? So I got to figure out how we're going to keep you alive, try to give you tools so that you don't lose everything around you. Most importantly, your life.
Right. And
it just worries me a little bit. I think you understand. I wasn't trying to punish you.
I know.
I I'm a little bit worried that, and I'm not saying that's not a good tool, that you keep yourself busy, but that you don't have other supports around you
I mean, I have
to make it,
quite a lot of support.
well, in terms of people,
Yes,
but in terms of treatment and in terms of other.
right, right. I mean, I do go to the methadone clinic and I mean, I'll be willing to do whatever, outpatient, I mean, I'm not sure what exactly to say here. I just,
No, I know. And
this is really hard, I just really didn't know I was going to be here this long. And everyone around me everyone I talked to about this in jail and everything, everyone's saying this is so excessive, the punishment for the crime. And I don't know, you know what I mean? I don't.
Those are the ones sitting in jail.
Right.
Yeah.
Right. Well, I mean, it's been the lady in community
know?
corrections would say, everyone's been saying it. And I don't know. I'm not a lawyer, that's all I've been told. I just,
He's just trying to keep you.
Right. I know. And that's what I'm telling them. I'm telling people I'm grateful for this intervention and everything. And I mean, I don't know.
I had a March 11th sentence. There, she said she'd see her.
She said she could be 225.
That's what I want. All right. So here's what I'm gonna do. I gave you a sentencing date of the 11th. I'm gonna move that up to the 25th of this month, so next week. Okay.
Okay.
My probation department will be down there to talk to you. And that way, what we can try to do is set something up for you, at least give you a framework so that when we let you out, you got some guardrails around you. And you got somebody staring down at you. That would be my probation department. And then you also have me staring at you.
So will I be getting out on the 25th?
That is my hope.
Okay.
That's what I want to do.
Okay.
Okay, that's why I'm moving it up. So we can give you all that stuff,
Right. And I appreciate that.
try to get you in the right direction and let you out and see how you do.
Thank you. Thank you. I mean, I owe you a lot. I really do.
Thank you for saying that. I don't know that you owe me anything. I'm grateful to you for being so honest and in the point of being so honest that you chose your life over everything else. So I'm grateful for that.
Some prison on this case, the Adult Parole Authority may supervise you for up to 2 years. If you violate the terms of that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that? Yes, sir. Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that? Sir. You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that? Yes, sir. At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Swift, the right to confront and cross-examine each of the state's witnesses. Do you understand that? Sir. You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that? You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that? The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that? Yes, sir. The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charges from the indictment. Do you understand that? Yes, sir. Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. And you could try your case to the court, I too would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that? Yes, sir. Do you feel like you understand each of these rights we've gone over? Yes, sir. And you understand that when you enter a plea of guilty, you'll be waiving all these rights. We're not going to have a trial. Yes, sir. This is how you wish to proceed? Yes, sir. Okay. Ms. Tranter?
On or about the 20th day of April 2025, Warren County, State of Ohio, defendant Charles Finley did knowingly obtain, possess, or use a controlled substance, specifically buprenorphine, a Schedule III drug.
Mr. Swift, anything on the facts?
Nothing.
Mr. Finley, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over?
Yes, sir.
What is your plea, sir?
Guilty.
All right, the court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Is there anything you'd like to say before I sentence you, sir?
No, sir.
All right. The court has considered the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So, Mr. Finley, I'm going to order you to serve 9 months in prison. I'm going to order that to be served consecutive to your current sentence. The court finds the consecutive sentences is necessary to punish this defendant. It is not disproportionate to the conduct of the defendant, and the defendant's conduct of this offense occurred while the defendant was already incarcerated in the Department of Corrections. If you have 0 days jail time credit on this 9 months, the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. As I understand it, you're probably already on mandatory PRC on your current charge. Is that correct?
Yes, sir.
So it doesn't really make a difference, but if you want, I can go over that with you again.
Waive it.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain programs sponsored by the Department of Corrections. Now, you have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me, sir?
No, sir.
All right, good luck to you, sir.
Ms. Ledford, after he steps away, can you step up from the podium with your drink?
Dina, you ready? All right. All right, this is case number 25-CR43211, the State of Ohio versus Jamie Ledford. Ms. Ledford is before the court with her counsel, Mr. Swift, Mr. Nicholson, on behalf of the State of Ohio. Last time we were here, the defendant had filed, and I forget, was it an NGRI or a suggestion of incompetency, or both?
I believe both.
Okay. At that time, the court was informed that there had been a recent report done by the Forensic Evaluation Center. Actually, the date of this report is January 2nd, 2026. This report was done for the Lebanon Municipal Court. The court has received a copy of this report and has provided that to counsel. Do we have a stipulation to this report and otherwise a stipulation that a new report was not necessary?
Yes, Your Honor.
We
All right.
stipulate that.
Okay.
The letter from Ms. Ledford, Judge.
Okay, I'm going to make this finding first because I think that based upon this report, the court is going to make a finding, Ms. Ledford, that you are currently still incompetent, as the Lebanon Municipal Court found. Based upon this report, and I know you're already at Summit, I'm going to find that based upon this report that Dr. O'Donnell believes that you are restorable to competency with the right treatment. So I'm going to find that you're incompetent but restorable within the statutory time frame, and that the least restrictive placement for that restoration is Summit. So you're going to stay there.
Until we find a place.
Well, it's not just finding a place. It's until things get leveled off.
Oh, okay, I see what you're saying. I thought you meant place.
Let me take a second and read this, and then I'll respond to any questions
Okay,
you
I'll
might
wait.
have. Sorry.
You're fine.
Okay. I'm gonna go ahead, Ms. Nicholson, did you see this?
I did not.
Okay, I'm gonna provide a copy to the prosecutor. Anytime you have communication with me, I'm required to provide both sides with that, okay? So we'll have copies made for your attorney and for Ms. Nicholson. And I'm gonna file this in the court's notes. It will not be part of the public record, but it'll be notes where I can go back and see this later, okay?
Okay, that's
Now, you heard my ruling. I'm not gonna change that based on this. I will wait to hear from the doctors at Summit, and they will update me with a report in short order, okay? And they'll let me know how you're doing.
And I have a question actually.
Go ahead.
Do you know when I go home, when I get a place?
You're gonna go home when you're better.
When I'm ready, you
Yeah.
know when that is?
Well, I'm not a doctor. I'm certainly not a psychologist. I'm gonna rely upon the opinions of the doctors at Summit. Does that make sense? Okay. Do you have any other questions for me? Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Swift?
Nothing, Judge. Thank
All right, very good. Good luck to you, Ms. Ledford. I will see you soon.
Thank you.
This is case number 25CR43084, the State of Ohio versus Eddie Napier. Mr. Napier is before the court with his counsel, Mr. Newberger, Ms. Tranter, on behalf of the State of Ohio. We're here for sentencing. Has everyone reviewed the pre-sentence investigation?
Yes, sir. Yes, sir.
Ms. Tranter, anything on behalf of the state?
No, sir.
Mr. Newberger?
No, sir.
Mr. Napier, is there anything you want to say before I sentence you?
No, sir.
All right, the court's considered the pre-sentence investigation, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court will find, Mr. Napier, that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, Your Honor.
All right. At this time, the only condition of your supervision is that you successfully complete Judge Peeler's recovery court. You understand?
Yes, Your Honor.
So I'm going to give you this opportunity. You have already been triaged and preliminarily found to be eligible for recovery court. I'm not going to make any further orders in this case, only because Judge Peeler just happens to have recovery court this afternoon. So I'm going to order you to be brought back over here to this afternoon for Judge Peeler, and he will make further orders with regard to your treatment and release. Do you understand?
Yes, Your Honor.
Now, you're also subject to a discretionary period of post-release control, which means if ultimately you're sent to prison on these charges, upon your release, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Do I have a jail time credit, please?
Your Honor, 137 days.
137 days jail time credit. Sound about right?
Yes, Your Honor.
All right. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost.
Can we put a no contact order on with the victim as well?
All right, Mr. Napier, you're not to have any contact with the victim in this case. Do you understand that?
Yes, Your Honor.
And when I say no contact, I'm not just talking about in-person or phone calls. I mean, no social media contacts. You're not even allowed to like their Facebook posts. You understand?
Yes, Your Honor.
You're not allowed to have somebody else contact them on your behalf. Do you understand?
Yes, Your Honor.
Any contact will be a violation of my order, and there will be sanctions.
Yes, Your Honor.
Do you have any questions for me?
No.
All right, Ms. Tranter, is there anything else?
No, sir. Thank
Mr.
you.
Newberger?
No.
All right, Mr. Napier, let's get this right, okay?
Yes, sir.
All right,
Thank
that's
you
all.
for the opportunity.
Yep.
Thank you, Your Honor.
All right.
All right.
See you in a week.
Okay.
Thank you, Judge.
Court calls the case, People versus Mark McIntosh.
Morning, Your Honor. Raymond Cook for the people.
First Judge, Court shall fix the Assistant Public Defender on behalf of Mr. McIntosh, who's approaching the podium. Please state your name for the record.
Mark McIntosh. Thank you.
Please assist the first pretrial on this matter. Asking for an adjournment to have time to discuss this matter more with Mr. McIntosh.
March 4th, 2026, 9 a.m. bond.
Might get moved.
Thank you.
All right. Thank you, Judge.
Thank you, Judge.
You're welcome. Hey, there we go. No. Court calls the case of the People versus Jessica Mahalik.
Morning, Your Honor. Raymond Cook for the people.
Brian Boley on behalf of Ms. Mahalik, approaching judge. Please state your name for the record, please.
Jessica Mahalik.
Judge, this will be a plea. There's a form in the file. She's been screened for the sobriety court participation as well at 14A, has been admitted. And so we just asked the court to accept the plea and hopefully we can get her into that program.
All right. The plea form indicates she's going to be pleading to 2 counts. Operating while intoxicated, second offense, the 1-year offense, and also driving while license suspended, denied and or revoked, the 93-day offense. And that's the full understanding. There's a sentence agreement of the 14A sobriety court. That's the agreement.
That's correct, Your Honor.
All right, man.
That's our understanding, Judge.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self you got?
Yes.
State your name, please.
Jessica Mahalik.
Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes, sir.
The first being operating while intoxicated, second offense. That is a misdemeanor punishable by up to $1,000 fine plus court cost, up to 1 year in jail. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
The second charge would be driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
To the charge of driving while license suspended, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes, Your Honor.
July 25th, 2025, at the location of 7000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
The night before I had 6 or 7 vodka cocktails, and then that morning I had a twisted tea mixed cocktail.
All right. Were you stopped by the police or?
No,
was
it's
it an
parked.
accident? You were parked?
Yeah.
Your engine was running, however.
Yes.
You're not disputing the right of the police to intervene and stop you and detain you. All right. Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station?
Yes, Your Honor.
Were you taken to the hospital for a blood draw ultimately?
Yes.
And what were the results of that blood draw?
0.278.
.27?
Yeah, 278, Judge. And we stipulate, we'll stipulate to those for the purposes of the plea.
All right. And you don't have any reason to dispute those results, do you, ma'am?
No, Your Honor.
All right. Had you previously been convicted on or about December 17, 2019 in the 34th District Court of operating while visibly impaired?
Yes, Your Honor.
Okay, on the date, back to the date of July 25th, was your driver's license suspended, denied, and or revoked?
Yes, Your Honor.
Did you know that it was?
Yes, Your Honor.
And you had been operating the vehicle while your license was revoked?
Yes, Your Honor.
Or suspended. All right, thank you. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of that and the time of my acceptance of the plea and the time of sentencing, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is aware of none.
And have I complied with the court rule?
You have, Judge.
Court will accept the defendant's plea of guilty to counts 1 and 2. Defendant is referred to probation, pre-sentence investigation and report. Has she been evaluated?
Yeah,
Obviously, she has.
Yeah, she met with Mr. Heaton. She's been approved. She was observed the sobriety court the last time we were there, last Thursday?
Yes.
And then they were hoping for a sentencing on the 26th if possible.
Who?
Mr. Heaton was my understanding.
Why is he trying to set my doctor?
He's bossy.
Oh. Yeah. People that are bossy, they run into me, they don't fare well. I'm going to set her sentencing here on the 25th. At some point, this court will work out.
Perfect. Thanks, Judge.
So February 25th, 2026, 9 a.m. So we'll get that part here and then we'll get you over there.
Thank you, Your Honor.
I'd love to be able to set a sentence in there directly, but I don't know why we're not doing that.
Yeah, I don't know. So we do have a sobriety court docket on the 26th in the morning, and I believe you're expecting to be there. So we should be able to get it resolved. Thanks, Judge.
Thank you. Court calls the case People versus John Hart.
Brian Bollig, Assistant Public Defender on behalf of Mr. Hart. How you doing, sir? Good. Just state your name, please.
John Joseph Hart.
Thank you.
I think we're moving to dismiss both of these matters. There was a plea on felony and you dismiss as part of that agreement.
I'm assuming you don't have any objection to those matters.
Yes.
Yeah.
Yeah.
Do you have an objection?
No objection at all, Your Honor.
You sure?
I am positive.
Did you have to think about it?
I did not have. to think-
Okay, all right. You look like
I'm
you were
ready to
having a
go
long,
ready to go to treatment anyway, so yeah.
you look like you
Thank
were
you.
having a long conversation about it. All
Trying
right.
to grasp the situation. Thank you.
You're all set.
Mr. Hart, take care of yourself. Court calls the case People versus Gerardo Morales.
Morning, Your Honor. Reading the people.
Brian Bollig on behalf of Mr. Morales. Can you state your name for the record, please?
Gerardo Morales.
Your Honor, we have a resolution in this matter as well. They'll plead guilty as charged to the no valid operator's license on person. There's a signed advice.
Fines and sentencing. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name, please.
Gerardo Morales.
There it is. It's court to understand you're going to plead guilty to the charge of no valid operator's license on person. That's a misdemeanor punishable by up to 90 days, a $500 or $100 fine plus court costs. You understand that?
Yes, sir.
Still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed any advice of rights form?
Yes, sir.
Any question regarding that?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
of your own free will?
Sir.
And because you believe that you're guilty of this offense?
Yes, sir.
on the date of January 10th, 2026, US 23, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating motor vehicle?
Yes, sir.
Did you get pulled over by the police?
Yes, sir.
Did they ask you to produce a driver's license?
Yes, sir.
Were you unable to give them a valid license?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
You have, Judge.
Court will accept the defendant's plea of guilty to this charge. Sir, anything you or your counsel want to say before I impose sentence?
No, sir.
I have nothing to say, Judge.
Fines and costs of $250. I'll suspend 90 days in jail. When can you pay that, sir?
How much was it?
$250.
About 2-3 weeks.
3 weeks, please, Judge.
By the 13th.
He said 2.
He said 3.
He said 2 or 3.
I didn't hear
He
2.
said
I heard
2
3. I
or
heard
3, and you just took the longer time.
Yeah, well, what would you expect me to do?
I don't know, but not that. Hurts my feelings. Can you get it paid by March 13th, sir?
Yes, sir.
All right. Pay it by March 13th, 2026.
Yes,
All right.
Thanks,
Thank
Judge.
you. Thank you.
Court calls the case People versus Trevor Howard.
People.
Brian Bowling on behalf of Mr. Howard. Howard, state your name, please.
Trevor Scott Howard.
Judge, we're asking for an adjournment of the pretrial matter to try to continue to work out a resolution of all of his cases. I believe there's 2 that are pending still, this matter and then a matter at the 15th District Court, if I'm not mistaken.
When are those set? Do we know?
The matter at the 15th District Court is on February 27th.
March 4th, 2026, 9 a.m.
May I address bond?
You may.
Your Honor, Mr. Howard has posted bond in the 15th District Court matter. He's currently obviously incarcerated. His mother is in the hospital at St. Joe's. The domestic assault and battery case that was pending before Judge Freshour was dismissed back at the last final settlement conference earlier this month. I can affirm that as I was his appointed counsel at that time. If I didn't say it already, he has posted bond in the 15th District Court matter. We're asking the court to consider a reduction in the bond here to, I guess what I would call a nominal bond, but hopefully $250 if the court were so. $250.
Response to the people.
In actually, I'm seeing that looks like on the domestic violence case, bond is still denied. I'll take Mr. Williams, where maybe actually it's taking a while to update that. I don't know if that case has been dismissed. It looks like his bond on the other matter was set at about 10%. On this case, bond was denied. It looks like there was a conditional release violation.
There was.
Off the top of my head, what that release violation was. But I got to say, see if I can find.
Yeah, go ahead. I'll look for my copy.
I think it was a new case, right? The 15th District Court matter. It was the 15th District Court matter, Your Honor, I believe.
That caused the violation on this one.
That's correct.
I don't think it's just discrepancies. Obviously, you can see the misdemeanors on that 15 matter. If the domestic violence, I'm assuming, is being dismissed. I would be fine with low cash surety bond. The court doesn't want to do that.
Good man. Sorry, I forgot to come to see you before the final settlement cards. I was there. Custody. But it all worked out. That don't make me think the person's never done show that.
I'll reduce his bond to a $3,500, 10% bond.
You did 3,500, I'm sorry.
Yes.
All right. Thank you, Judge. 350. Okay. All right, never take care.
Thank you. Have a good day.
Thanks, yeah. Thanks, Judge.
Court calls case People versus Penny Muldoon.
Your Honor, we're going to the people.
Hello,
Hello,
what's your name?
Penny Muldoon.
All right, ma'am, you are before the court on a misdemeanor complaint that alleges that on or about September 29, 2025, at the location of 5400 State Street, Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with the presence of a controlled substance. You understand that charge, ma'am?
Yes, sir.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The court could order community service any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
First question I have for you, ma'am, is do you want to be represented by an attorney?
Yes, please.
This is a public defender case.
Torso Feaster, Assistant Public Defender, on behalf of Ms. Muldoon. She's away from a reading, Your Honor, stand mute.
And in every way from reading, standing mute. Court will enter a not guilty plea. Seeking an adjournment.
Please, Judge.
I'll adjourn this matter to March 4th, 2026, 9 a.m. Set the defendant's bond at a personal recognizance. She has no priors, is that correct?
None to the people's knowledge.
Set her bond at a personal recognizance, $10,000 bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any other illegal drug. You understand that, ma'am?
Yes, sir.
I'm also going to order that you go over to community corrections for placement on testing. I'm ordering testing. If I ordered you to test today, would you test clean?
Yes, whatever I have on me, I have a prescription for.
I'll order testing one time per week, random.
Thank you very much, Judge.
Thank you. Court does call the case of the people versus William Matthews.
So we have to township in front of the people.
Judge, Attorney Feaster, on behalf of Mr. Matthews, please state your name for record, sir.
William Matthews.
Thank you. All right. I don't believe that the police sheet's in the file already. Do you have a police sheet already in your file, Your Honor?
Pardon?
Do you have a police sheet in your file already? Okay. And I guess we're gonna be requesting a short adjournment
All right.
and requesting to address bond, Your Honor.
Is he held on anything else?
I got an MDOC hold and a felony.
Gotcha.
Got $100 bond, well, 10% on a felony.
I'm not gonna change his bond. You can argue it, but if it's the NDOC, hold on.
I think we just want to make
Have it
sure,
resolved.
I think we just want to make sure he had a bond in this case.
Yeah, to get like a bond, so there would be able to get time served.
He wants to,
I think he's,
probably on dead time, but if there is
I
a,
think his bond. What do you have his bond? I have his bond set, I think at $1,000, 10% on each case.
that's fine then.
Oh, that's cool then. Yeah, if that's it. I thought it was a PR bond, but if it's.
Is that what you have? Oh, you see a PR? All right.
Looks
This
like,
might have changed it. I don't know how that changed.
That's the same on the other one.
All right, then I'll set his bond on these cases at $1,000, 10% bond on each case.
That'll work.
did you set your,
And I'll adjourn his case to March 4th, 2026, 9 a.m.
thank you, Judge, sound perfect.
Thank you, sir.
All right, thank you.
That's average
Court calls case People versus Erica Scott.
For the people.
Torso Feaster, Assistant from Erica Scott, who I believe is approaching the podium. We'll bring her to you one, please, sir. Please state your name for the record.
Erica Scott.
Thank you, Judge. Looks like we were negotiating with the people trying to receive a. Looks like we're still in the.
How old is the little one?
She's 7.
She's 7?
Yeah, she's on midwinter break, so she had to come with me. Yes.
And then you just tossed her into the back row?
I'm sorry. You want to come?
You just
up?
tossed her into the back row?
Well, come on.
She's just following.
Come on, babe.
Hello, young lady. Hi, what's your name?
Ombre.
Ombre.
Ombre. That's a beautiful name.
Thank you.
All right.
Thank you, Judge. I think we're still negotiating. If we could have a brief adjournment, that'd be greatly appreciated. Yes. That's okay.
Yes. Well,
I have it now.
Okay.
Okay.
yeah, let me go March 18th,
Thank you, Judge.
2026, 9 a.m. All right. You're on midwinter break? I'm gonna take a midwinter break too.
Just look at that date. I might, that's around my due date.
I had to, on her other case, she has another case, 1761. I'm gonna cancel the warrant on that.
Thank you, Judge.
And I'll set a PR. Well, she hasn't been arraigned on that one. Hold on a second. She was arraigned on this one, on the driving while license suspended. On the other case, she hasn't been arraigned. All right, ma'am, you are before the court on a complaint that alleges, it's actually the same ticket. On the date of October 18, 2025, Ellsworth Road in Pittsfield Township, that you did operate a motor vehicle without security or insurance. You understand that charge, ma'am?
Yes.
That's a misdemeanor punishable by a fine between $200 to $500 and up to 1 year in jail. You understand that?
Yes.
All right. You wish to be represented by an attorney on that
Yes.
public defender case?
Commercial Feaster, Assistant Public Defender. Your Honor, we waive formal readings to unmute and ask for an adjourned pretrial date.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. That or other case before. So I'll adjourn this matter out to the 18th. Cancel the warrant. I'll set a personal recognizance $5,000 bond, standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes.
All right.
Just so the court is aware, 3/18 is close to her due date. So 3/18 is close to her due date. So if she does go into labor, we'll let the court.
No. She needs to be here.
Yes, sir.
Bring both the babies.
Well, if you had the baby beforehand, yes, bring the baby. However, if you're like in labor and that might happen here, go have your baby, because I'm going to be of absolutely no help. Somebody else will have to do it. The only thing I know how to operate is a defibrillator, and that's not going to do it.
Got it. Mhm.
All right.
Thank you, Judge.
All right. Thank you.
Want to take of it.
Bye, little one.
Bye bye. Bye.
Bye. Court calls case People versus Jason Smith.
Conrad Solar on behalf of Pittsfield Township.
Yes.
Ready, Judge. Court Feaster, Assistant Public Defender on behalf of Mr. Jason Smith. Mr. Smith, please state your name for the.
Jason Smith, Your Honor.
Thank you.
Morning, sir.
Thank you.
Morning.
Thank you, Judge. I believe Mr. Smith met with Mr. Brown in custody. We're still trying to get the offer that this wants. We're asking for an adjourned pretrial date.
March 4th, 2026, 9 a.m.
He's a different offer. We're trying to get it up.
Okay.
We'll connect March 4th.
Okay. Thank you.
Thank you, Judge.
Bond continued. Court calls the case People versus ES Smith. ES Smith. Hello,
Hello, Judge.
what's your name?
Lydia Smith.
All right, ma'am, you are before the court on a misdemeanor complaint that alleges between the dates of September 12th, 2024, September 20th, 2024, while you were an agent or trustee of Walmart, that you did embezzle funds less than $200. Do you understand the nature of that charge, ma'am?
Yes, sir.
All right. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased if 3 times the value of the property that is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
Public defender case.
Brian Bowling on behalf of Ms. Smith, Your Honor, we'll stay on mute to the complaint that you just read. Ask for a pretrial date so that we can speak to Ms. Smith.
And then having further formal reading, standing mute, court will enter a not guilty plea. Oh. I'll adjourn this matter to March 4th, 2026, 9 a.m. As to bond.
Your Honor, Ms. Smith is 19 years old. She is employed by the University of Michigan. She's a graduate of Romulus High School, correct? She indicates no criminal history of any sort, Your Honor. She obviously appeared here this morning. I'd ask the court to consider setting a personal bond in this matter based on her appearance here today.
Do you live on your own?
No, I live with my mother.
Is she here? So she knows about this?
Yes, sir.
When did you graduate high school?
2025.
You going to college or what are you doing?
I'm planning on going this year, Washington Community College.
What do you do at the university?
I'm environmental services, so
So you're planning on going this year?
yeah.
Let me ask you this. You graduated. What'd your mom say about you planning on going later to school, to college?
Well, I went after high school, went straight to working, so I'm helping with.
Okay, I get that, but what did your mother say about that?
As long as I go to school.
As long as what?
As long as I go to school and I have a
So
plan.
you could go and work. She didn't mind that, but you were supposed to go to school if you get your education.
I'm going to both. Yeah.
Huh? Well, is that what she was telling you? What? You're nodding. You can use your words.
Yeah.
That's what she was telling you.
Yeah.
And so you graduated when?
2025, June.
June of 2025. So we went past September of 2025 because that's when the school year was starting.
When are you intending to enroll?
And then she's not. So let me ask you this. How do you feel? How's your mother feel about you not being in school yet?
She's trying to tell me to hurry up, but besides that.
She said what?
Hurry up, do something. But.
She said, hurry up, do something.
Like as in school wise?
Yeah, okay, so that means she's probably not pleased that you're not in school.
I wouldn't say that, but
Are you working full-time?
yes. full-
Mom, you want her in school? Now, how come you're not doing what your mama wants you to do? Because you're not grown yet, because I got a whole bunch of grown folks back through that door if you want to be grown. Okay, maybe I'll put it this way. When are we going to school? Because I can provide alternatives to that, but I don't think you'll like my alternatives. I am gonna make your mother's wish come true. You are going to school one way or another while your case is before me.
Of course. I was planning.
Wait, well, see, you sit there and say, of course, I want you in school.
Me.
When are you going to enroll?
Oh, I'm already enrolled, is what I'm saying. I don't have the classes and registration started yet for this yet. So.
Why?
Because I'm doing school and because I'm out paying the bills, so I could stay in the house. If that makes sense.
It makes sense, but that doesn't mean that you can't take some classes. Or what, even. Here's the problem, young lady. When I get somebody like you in front of me, here's my big worry. Your mom wants you to go to school. I think you really want to go to school. Right? But I also am aware of the statistics that the longer you stay out, the less likely it is that you will go back.
Yeah, I know those statistics.
So when I get somebody like you, I grab you and I make sure you go to school, even if you're taking one. Got it?
Yes, sir.
So when are we going to get enrolled? Well, when are we going to set up a class? Here's the thing.
I don't know how that school works, so it would be within the
I
next.
don't know how it works. Great. I teach there.
Okay.
So I can tell you how it works. What are you doing today?
What am I doing today?
Yeah.
I'm actually gonna go to my doctor's appointment. So.
Okay, well,
After
that's
that-
important. So do that. So when are we going over to Washington and checking the classes?
Are they open today or tomorrow? Well, I work tomorrow. Hold on. So probably that.
Are they open? Yeah, they're open. Here's what I want, okay? What are you worried about going to school?
Nothing. It's nothing that I'm per se worried about.
Pardon?
Nothing that I'm worried about.
Here's what I want you to do, young lady, okay? Sometimes the hardest step to make is the first step. Okay? So between now and March 4th, you're to get yourself over to Washington. You're to check into classes. Okay?
Yes, sir.
Let's start this journey now. Okay? A good reason why your mom wants you to do it. Okay? And one of the reasons is that she believes in you and she believes in your future. That's why she wants you to do it. That's why she's also telling you to hurry up. Because she'd like to see it, because parents get great joy out of that, okay? And the other thing is, I'd like to see you do it. I think you could do it. I think you want to do something else with your life. And it's not going to be easy, but you can do it. Okay? Go over there. The people over there are wonderful. They will help you figure it out. Figure out what you can do to try to not make it so stressful on you. And try to figure out how to get yourself started. All right, young lady? What are you crying about?
Nothing.
Nothing? You just cry about nothing?
Yep.
It's like my daughter. I don't understand it. All right, look. Go over there, you got 2 weeks. Get yourself over there. Take a look at it. Have you even looked at their programs over there?
They don't have really the one that I'm looking for. So I was talking with my counselor, but
Pardon?
I said they don't really have the program I was specifically looking for.
Which
but,
is?
Marine biology or biology.
Marine biology. Why do you want to be a marine biologist?
Why not?
Wow. I guess I'll ask it a different way. What interests you about it?
I don't know, the ocean.
The ocean?
Weather. Yeah.
You ever been there? Which one?
The Atlantic.
How'd you like it?
It was nice.
Yeah. And maybe somebody after my own heart, if you say you're gonna be a marine biologist. I'm not a marine biologist. No animal, I probably can't keep an animal alive to save my life except a dog. But University of Maryland has an excellent marine biology program. And that's where I graduated from. So I get it. There's something about the attraction of all of that. But here's the thing. It doesn't mean that you can't start your journey on some of the stuff that you're going to need to get yourself there, right? I mean, they may not have the whole program, but you could start it out while you look around as to where else you're going to go, like the University of Maryland. I mean, where else you might want to go, okay? All right. So go over there, check in, and just tell them that's what you're interested in, and they can at least try to develop a path for you to head forward, okay?
Okay.
You're 19?
Yes.
Nothing else that happened today that you remember. Remember this one thing that I took, okay? And that is you got dreams, follow them. Okay? All right, young lady, we'll see you on the floor.
All right.
Hang on a second, I gotta get a phone number from you.
Thanks, Mom.
Thank you.
Court calls the case, People versus Jacob Snyder. Your name, sir?
Jacob Snyder.
Sir, you are before the court on charge of no insurance under the motor vehicle code. That's alleged to have occurred on or about January 21st, 2026 at the location of eastbound I-94, Pittsfield Township, Washington County, State of Michigan.
That's correct.
You understand that?
Yes, sir.
So misdemeanor punishable by up to 1 year incarceration at $200 to $500 fine plus court costs. Do you understand that, sir?
I understand.
All right. You wish to be represented by an attorney?
Not entirely sure, sir. As far as I was aware, what the officer told me was I could show up and present that I had bought insurance and that this would be waived. So that's kind of what I was looking at.
Well, I think I don't know.
But I'd say yes.
What would the people do?
Your Honor, my standard offer is that if I receive proof of insurance, I would be moving to dismiss this matter.
You got insurance with you?
I do.
Do you?
I have that on my phone. I have a.
You want to dismiss?
I would like to.
Can you show him the proof of? What are you waiting for, young man? Jeez, oh, Pete. Okay. You can have it dismissed. He's taking so long. He's like, he's got it on my phone. Well, get it out. Watch this. Cook's gonna say, I don't know if I can do this again.
And people will be moving to dismiss.
Wow. Any objection?
No.
Case dismissed. You have a great day, young man. Court calls the case, People versus Caitlin Stevens. Hello, what's your name?
Caitlin Stevens.
All right. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about September 10th, 2025, at the location of Huron Valley Correctional Facility, that you did contrary to statute, falsely report the commission of a misdemeanor, that being 4th-degree criminal sexual conduct. Do you understand the nature of that charge, ma'am?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes, sir.
First question I have for you is, do you wish to be represented by an attorney?
Yes, sir.
This is a public defender case.
Sorry, on behalf of Ms. Stevens, waive formal reading and stand mute, Your Honor. Ask for a pre-trial date so that we can speak to Ms. Stevens.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
29.
Any criminal history?
Pre-trial in this matter will be adjourned to March 4th, 2026, 9 a.m. Set her bond at $5,000 personal recognizance bond, standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes, sir.
All right.
Thank you, Judge. Have to get a photo. Okay.
Court calls case People versus Blaine Taylor.
Morning, Your Honor. Raymond Cook, the chief.
Blaine Taylor. Here. Bond will be set in the amount of $5,000. We'll give a 10% privilege. That warrant will issue immediately. Calls case People versus Antoine Thomas.
Morning, Your Honor. People.
Your name, sir?
Antoine Thomas, sir.
All right, sir, you are before the court on a misdemeanor complaint that alleges that on October 10th, 2025, at the location of 3300 Carpenter Road, that you did operate a motor vehicle without security or insurance. You understand that, sir?
Yes, sir.
That's a misdemeanor punishable by not more than 1 year incarceration, a $200 to $500 fine plus court costs. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney, or you got your phone out, you want to show them something?
I do have my.
You want your phone out, you want to show them something?
Yes, sir.
You think yours will work this time?
Absolutely.
You know what? If you blow this, it's going to be a problem. All right, go ahead.
No, not this vehicle is, I don't currently have this vehicle when it was controlled since the matter, but during the time, that's to show that during the time I had insurance.
Gotcha. Give me just 1 second, Your Honor. I'm just checking the date.
Sure. You need the date of offense?
Yes, please.
Date of offense was October 10th, 2025.
People move to dismiss.
Wow. Did you see what he did? Unlike the other guy, he just handed a phone and he did it. He had to do some explanation. Do you have any objection to that?
No, sir.
Case dismissed.
Thank
You
you.
have a
Good
great day. He's doing better than, they're doing better than Feaster. They're getting, no, I'm just saying. I just didn't mean to blurt that out loud. The court calls the case, People versus Tito's. Why ho ho no? Why ho ho no?
Good afternoon, Your Honor. Raymond Cook for the people.
All right, you're gonna have to help me with that name.